Professor, quotal number 21, na? Professor,
ಹೇಳಿ ಸರ್.
quotal number 21, na, madam?
21 ಸರ್.
Okay, madam. Okay, thank you.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಬೇಕು ಇದೆಯಲ್ಲ ಆಗಿದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ.
ಅಲ್ಲಿ
ಅವ್ರಿಗೆ ಇದೆ SOAR ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ.
ಓಕೆ
ಅದಕ್ಕೆ ಮೇಡಮ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ, ಪ್ರತಿದಿನ ಹೇಳ್ತಾರೆ ಮೇಡಮ್.
ಗೊತ್ತಿಲ್ಲ, ನಾನು ಇವತ್ತೇ ಇನ್ನೊಂದು Oriental is son.
ಅವ್ರಿದ್ರೆ ನನಗೆ ಕೇಳ್ಬೇಕು. ಇಲ್ಲ. ಆಮೇಲೆ submit ಮಾಡ್ಬೇಕು.
In case any defense strike down must be. Defense strike down. Straight there. Ganesh with the 40 years. Ganesh and Judge. When 3 days army, all day, order medicine, date, My lord, I am sorry to submit, my matter was dated on 18/9, but abruptly it was listed on 11/9. I was held up in Vijayawada flood relief camp. I did not know it will be listed on 11/9 from 18/9.
So what is that you want now?
I have filed an IA order 1 rule 10(2).
That's for when is it listed on that day?
It was originally dated on 18/9. Abruptly it was listed on 11/9. It did not know that. I was not.
You cannot say abruptly, whatever is the order that day, it will come on that day. There must be some, what you heard is not right. That you have to put it that way. Yes, what do you want now?
It may be taken on 23rd, urgency is there, madam.
We'll see, give it to her. Yes,
Humble submission.
23rd.
hey, give it to her. Yes,
My lord, this matter was memo was posted before this honorable court on last date, and this honorable court has given the date on September 10th, but it was not posted on that day. So I am submitting again this memo before.
take that, yes,
It also have annexed the medical certificate.
yes,
to continue
yes.
the
Fresh matter, if the objections are complied with, it will come. Look at it, why it is not coming in spite of office objections being complied. Yes,
My lord, trial court has taken order
you have to come this way. Again, I'll not go. I'm telling to her, yes, come this way.
My lord, GMFC matter, my lord, trial court has directed to register the complaint, my lord, against the petitioner for perjury. My lord, there is an interim order of stay, my lord, I have filed a statement of objection, my statement of objection.
Which year is that?
It is a 2024 matter. There's a order-
Well, it will come next week, yes.
22, my lord, this is a succession matter wherein the succession matter was dismissed by the trial court. They have filed an appeal. I am appealing for the respondent. There is already a 22 years back succession certificate issued in the male members. So now she has challenged that trial court order. Therefore, there is urgency. 2 years after that.
What is order by this court? You're for
Issue notice. After 2 years, the matter was not listed for admission.
next week.
My lord, the matter is
matter.
pending to the trial
The next
on
week,
19th,
the
my lord. My application 13 and 2 has been rejected. Can I have it tomorrow?
Which year is that?
24.
Huh?
2023.
That's the whole difficulty. Everybody wants 19, 20 matters to be listed. You know, all those matters will be tagged to this list. You know, what happens is whether the court will be able to reach all those matters and complete it. That's a difficulty.
No, no.
You're seeing that all the lists for the next week also, it is almost 50, 60. MFA is 50, 60. How can the court complete? That also you have to understand. We'll see. Yes.
Fresh matter, my lord. 39 rule.
Fresh matter, if the office objections are complied, it will come. If in spite of that, if it is not coming, please tell the court officer.
It's something to complain, my
Huh?
lord. Respondent is
That's what, if the office objections are complied, it will come.
kindly have it on tomorrow, my lord. Respondent,
If it is complied with, it will come. That's what I'm saying. Take that.
My lord, my application has been rejected, my lord. 39.
What were you doing from 23 to till now?
It was listed on February, my lord. Issue
It will
of-
come. It will come. There are so many matters of that
Can
nature.
I have it tomorrow, my lord?
No,
This foreign has been interpreted into my.
give
property, my
give the memo you mentioned. I understood.
tomorrow.
Yes, no, it will not come tomorrow. Yes, page wise mentioning.
Page wise adjournment, page 1, serial number, list 1, page 1, serial number 1 to 4, page 2, 5 to 14,
My lord, serial number 12, my lord. I filed a
Anita, increase the speed of the fan. Yes,
memo for withdrawal, my lord.
which one?
Serial number 12, my lord. The main MC, my lord, it was settled before the mediation.
The memo is fine, seeking to withdraw the petition. It is submitted that The MC itself is settled before the mediation center. Accordingly, dismissed as withdrawn.
Great.
Yes, next.
Serial number 11, my lord.
Number 10, my lord.
Serial number?
10.
Huh.
Even it has been settled, the MC matter itself has been settled. Rendered in front.
Memo is filed seeking withdrawal that the main MC itself is settled. Yes,
Serial number 11, my lord.
yes.
Praise for some time, my lord. Next week, kindly have it.
Want the time in a 2021 matter.
My senior is unwell, my lord. Next week.
What is this O?
13.
To 11.
That is GMFC.
No, something is below O. That's other matters. Or 11. no? Yes. 11.
Dismissal.
What is that O? That I'm asking. Huh? Let's see when it reaches what it is. Yes, next.
Page number 3. Serial number 15 to 23.
19, madam.
Yes.
19, madam. I'm for petitioner. It may be taken up next week, madam. Matter has been settled. I will keep the pres-
Matter on 15th of October at the request of non-constant.
interim order may kindly be extended.
Interim order earlier granted is extended. It is submitted that its matter is almost settled. Yes.
Serial number 17, matters become infructuous, the criminal miscellaneous is.
It is, a memo is filed stating that the criminal miscellaneous itself is disposed of. Accordingly, the writ petition is dismissed as withdrawn. Yes, next.
Serial number 18, my lord.
16.
Yes.
Not trying for petition in this case. I see 1 week's time not seen.
We will see why the matter should be listed and unnecessarily. We will see when the matter reaches, we will not adjourn the matters. No, the matters will be adjourned. Again, this comes for a memo. Again, it has to be listed. We will not adjourn any of the matters unless and until there are compelling reasons. And if there are no compelling reasons, don't mention. We will see when the matter comes and it really requires time, then we will grant. Yes, next.
Serial number 20, I undertake to file wakalat. I am for the respondent in that. I have been served with a copy.
Have you informed the other side?
No, my lords, I have.
That's
I-
why, please wait. Yes,
Please,
next.
I shall.
Serial number 18, my lord.
Hmm.
Senior went to Sabrimala.
Huh?
Sabrimala, senior went to Sabrimala.
I'm ready to address the argument.
I am for the respondent. Respondent.
I'm for petitioner, I'm ready to address the argument.
We will see. We will see. If any, your senior's presence is required, then we will adjourn the matter.
My lord, my argument will be in next week.
Yes, you be here when the matter is called. Yes, next.
Page number 4, serial number 24 to 24, 25. Page 5, serial number 26. Page 7, 27, 28, 29. Page
28, my lord.
Root was disposed of.
Memo is filed stating that the suit itself is disposed of.
28.
Accordingly, the MFA is dismissed as withdrawn. Yes, next.
page number
Serial number 28, my lord.
20?
28,
Yes.
my lord.
Yes.
We are given NOC, my lord, but our name is showing. Kindly have it on next week, my lord.
For whom?
For appellants, my lord. We given NOC for appellant.
When did you give NOC?
Last date, my lord. When last date only
Have
we
you
given.
filed any memo of retirement?
No, ma'am. No,
And
ma'am.
then how will, then your name will be, how will the court know that you have given NOC?
So for that one reason only 1 week, my lord. I will file memo, my lord.
Pose this matter next week. Yes.
serial page number
Okay.
7, serial number 30.
My lord, serial number 30.
Appellant, my lords, in this, I have received NOC wakalat only
Yes.
today, my lords.
The underlying suits have been dismissed, my lord.
Serial
I
number?
have received NOC only today morning. My lords may have it
38?
tomorrow. My lords may have it tomorrow. I have received NOC only today.
No, if you receive NOC and he wants to withdraw the appeal, how are you? how can you-
I'm for the respondent.
That's my appeal. I was just.
I'm for the
served with,
respondent.
Huh?
I'm for the respondent, my lords.
The suit, my lords, the learned friend is saying that.
Oh, please, 1 minute. What is this?
My lords, the underlying suit has been dismissed for non-prosecution. I'm just placing that on the record.
What remains?
My lords, kindly have it tomorrow, my lords. I'll have it withdrawn, my lords. I'll seek instructions. Only today morning I have received.
That you can have in the afternoon also. Why it should be listed again? Please get instructions after Passover.
Please, oblige.
Yes, next.
Page number 8, Cell number 31 to 33.
Cell number 31 and 32 appear for the appellants. Need some time to file additional documents. Also inform the opposite counsel.
You appear for
Appellants, in both the cases.
31 and 32, post these matters on October 29th.
My lord, I
The
have,
request of learned counsel for the respondent, appellant.
my lord, I have one submission, my lord, in cell number 32.
Yes.
This one court had ordered that, my lord, the amount in deposit be released. Now the records have come here, my lord, the trial court is not in a position to release it. My lord, may I make a request, my lord, I'll file certified copies before the trial court and seek for release of the amount, my lord.
It is submitted that as the court has already called for the trial court records, though there is an order permitting the petition, the claimant to withdraw the amount, the same could not be done. The claimant is at liberty to file the certified copies and seek the permission from the court for withdrawal. Yes.
Much obliged.
Interim order earlier granted is extended till the next date of hearing. Yes,
Much
next.
obliged.
10. Cell number 34 to 38.
Cell number 35, madam. Respondent also seeks some short accommodation personally because.
No,
Already has informed.
no short accommodation is only long. Because you see the pressure of member.
Serial number
At the request of learned counsel for the appellant or the.
And the respondent number 5 to 8, madam, 1 week.
Huh?
Praise for 1 week, madam.
Have you informed the appellant?
I'm the appellant.
You have no objection.
Next week, need it.
Next week, not possible. If you want
First week, at
adjournment,
least first week.
pose
October
these
first.
matters, both the matters, at the request of learned counsel, the respondent on 21st of October.
My lord, serial number 36, my lord, kindly have it tomorrow. Senior is out of town. He'll be back tonight. Serial number
Tomorrow.
36.
Page number 10. Cell number 39 to 41. Page 1. Cell number 1 for preliminary hearing. Vedavati GK for petitioner.
You there? Notice to the respondents. Petition is permitted to take out notice on the counsel appearing for the respondent, the trial court, and shall file a memo to that effect by October 15th. If the memo is filed, list this matter on 16th.
Cell number 2. Ashok Vidit
So I appear. Ashok Bani, yeah. My lords, I appear for the petition in item number 2, my lords.
Yes. What are these two red petitions?
Lords, it's with regard to custody, my lords. We are claiming, I'm representing the grandparents, my lord. They have lost their
No.
daughter.
No,
Yes, ma'am.
WP 14632, you are the appellant.
Yes, my lords.
You appear for the writ petitioner in the other writ petition.
My lord, serial number 2, MFA.
Yes. There are two MFAs. Writ
No,
petitions.
WPs, my lord.
Two writ
Writ
petitions are
petition.
there. First writ petition, he appears. Second writ petition, you appear. No, the advocate's name is different. 2 and 2.1.
My lords, item 2, I represent the writ petitioners, Sri G. Muniraju and others.
That's what I'm asking. Whom he appear, for whom he appear. Yes.
My lords, I appear for the,
What happened to your video? Yes.
my lords, there is some,
Yes.
First matter, grandparents are the applicants.
First matter, he appears for the grandparents.
yes, my lords.
You appear for the father.
I appear for the father.
Yes.
Matter went up to Supreme Court, my lord. The issue here, an interim order was passed so far as the custody of child during the summer vacation. It had come up before the vacation bench. This honorable court, coordinate bench, modified it because it had given continuous custody after interviewing the child. the lordship felt that continuous custody would not be necessary. He gave access for a limited period. The lordship set a date, it's in detail into manner, that was followed. They do not
Mother
have
is
to-
no more.
Sorry, my lord.
Mother is no more.
Mother is no more. Now, foster mother is there, my lord.
Huh?
Respondent has remarried, my lord.
Oh.
There's a foster mother. Now, the ill will is against the second mother. They
Mm.
say foster mother is tutoring the child and all, whereas we say that she is not comfortable with the grandparents. In fact, that is noted down when the coordinate bench lordships interviewed the child.
What is the age of the child?
My lord, the age of the child now is, my lord,
Almost 6 years.
6 years.
6 years, my lord.
Let's see let's look at the order. Let's look at the order.
Please, my lord.
Yes.
Order is, my lord, in this petition. my
First
lord.
petition in WP 14632.
My lord, order is page number 77, my lord. I'll go to the relevant portion, my lord.
Yes.
The relevant portion, my lord, page number 86, my lord.
Hmm.
Para number 13, my lord. The learned trial court judge observes as follows, my lord. He narrates that he has interviewed the child in camera and all those things. And
Let's read that. It's only one page.
please, my lord. Page number 86, my lord. Para number 13. May I read, my lord? It is important to note here what has transpired during my interaction with the minor child in the in-camera proceedings held on 27/3/24. During my interaction, the cute girl child said her name as so-and-so, age 7 years, studying in 2nd standard at National Public School, and she is happy with her parents. I am also convinced that child loves the petitioners, that is the grandparents, my lord. The allegations and counter allegations are subject matter of trial. Therefore, considering the love and affection of petitioners towards child, and also the attachment of the child towards the petitioners, that is grandparents, in order to avoid any strain
Here
in
the
their
referring
relationship.
to petitioners means
Grandparents, my lord. Petitioners are grandparents and her uncle, maternal uncle. In order to avoid any strain in their relationship at this juncture, I am of the view that if the instant IA is partly allowed by granting visitation rights to them and permitting petitioners to take child to their custody during the summer vacation for a period of 10 days from 1/5 to 10/5. Here continuous 10 days custody was granted, my lord. It would meet sense of justice. Petitioners are also entitled for visitation right who can meet the child every Sunday from 10 a.m. to 11 a.m. My lord, I have not challenged this in my petition also, my lord. Either at the house of the respondent.
Let's see the order. What is this?
Finally,
The
the order
petitioners
is
1 to 3 are entitled for interim custody of the minor ward.
for
during
10 days,
summer
ma'am.
vacation. You are not agreed by this.
10 days continuous custody, I was agreed. That's the reason the second petition I filed, it came up before the vacation.
But
bench.
10 days custody.
Please, my lord, that was altered, my lord. We only said that we are not against the child meeting grandparents, but 10 days and that too overnight custody, we are apprehensive. The lordships also interviewed the child. He has noted down his order also. And he modified it saying every Saturday and Sunday during the vacations also, weekends they can spend time.
What happens? If
They met, my lord.
No. If it is 10 days, what will happen?
Well, 10 days in their continuous custody. In fact, the child had narrated before, it has narrated before me also as a counsel also, when I had to write the petition, and also before the lordships of coordinate bench, that she was not convinced in in staying overnight with her grandparents for a period, continuous period. She also clearly said she is not apprehensive of meeting her grandparents. She is willing, even we have no problem, my lord. We cannot deny the right of grandparents meeting the child. But we are only continuous custody is what we are agreed by. For a period, maybe for a period of 2 days to 10 days, whatever it is, and also overnight stay with the grandparents, we are apprehensive because they may tutor the child. They may have effects on that because that child has stated, in fact, it's stated before the lordship. After that, in fact, in the order also, the lordships have narrated that any further arrangements has to be made. It has to be by interviewing the child. The lordships has noted on it. My submission before lordships is, my lord, I'm not agreed by child visiting. In fact, in my petition, in this, the learned trial judge gives twofold orders, my lord. One is for a period of 10 days, which was modified. The another is meeting on Sunday for 2 hours. Till today, I have no objection. In fact, in my petition, I have never challenged that child meeting on Sundays for 2 or 3 hours, my lord. The child had mentioned to the father of what certain ill will things his grandmother and maternal grandfather, we have absolutely no problem. She is very comfortable. The grandmother and the uncle, who is also the petitioner, her deceased mother's younger brother, my lord. they used to tutor certain things against her father and the foster mother, my lord, which she is very comfortable with her father. She's doing excellent in academics. That is the reason, because of her mind. It was not our force or anything, my lord. In fact, if I'll most humbly submit, my lordship can interview the child also. I'll keep her present. You can ascertain the lordship can ascertain the mind of the child, my lord. She says, I have highest respect for my grandparents. I will meet them. I'll talk to
Girl
them.
of 6 years cannot say so many things.
Exactly.
The girl
Malad.
of
that
6
is
years
what-
cannot say what you are saying. That
Malad,
I have
may I
great
suggest,
respect
Malad?
to my
Malad,
grandparents, I'll stay with
Mine,
them.
in fact, I have not spoken to her for long because I do not want it to be moved by her. She had narrated it before lordship. What was my instructions? I had stated. Even till today, in fact, this matter, this order of coordinate bench was challenged before the petition in first petition before the apex court. Apex court did not even entertain it. They remanded it back.
No,
My
they
most
they
humble-
gave us liberty, my
No,
lords.
let him complete.
Yes, yes, yes.
That is what my lord. Lordship said before the appropriate forum. My humble submission is, my lord, now he filed an application for a certain arrangement during the summer vacation. That was granted. We challenged it. This High Court has modified. Now, if he requires any further custody or anything, he is always at liberty to approach the.
It is not about
Learn
only
exit.
one summer, it is general order.
It is general. My
So
humble
no,
submission also,
no,
my lord. In
no,
fact,
if that has to be changed, it can be changed by this court.
please, my lord, I am not
Again, for that, again, another round of litigation
not
going again
required,
for the trial court, all those things
Yes,
will not
my lords.
arise.
not required, my lord. That is the reason, my lord, I fairly submitted, my lord. That order, the impugned order, has twofold. One is during summer vacation. That part is now infructuous because it was
Forever,
modified.
why it should be 1 to 2 hours?
My lord, I am only,
Why not she spend some time with them?
my lord, more as
Until she
I'm not on specifically on,
spend time with them, how will she understand?
my lord, I'm
That too, now court has to understand that the tutoring is from the father to say all that.
please, my lord, my difficulty is, my lord, what the father, the petitioner has informed me is, my lord, the child is refusing to go. He says, I have seen when the child was called to appear before this court during summer vacation work coordination, she was not willing to go. Lordship interviewed her, lordship convinced her and said, this is it. You will have to go. The child is,
That order passed by this court.
please, my lord, may I, lordship certificate, my lord. Page number 11. One 118, my lord. 119, my lord, fourth paragraph. The above was what was modified, my lord.
Let her go to the grandparents for 2 days in the vacation. We will see what will happen.
My lord, I do not mind her spending from morning till evening, my lord. In this order, which was passed by coordinate bench, my lord, after interviewing the child, the lordship felt that she is comfortable visiting her grandparents within the apartment complex of the petition.
When the mother died,
Lord, immediately after birth, I think immediately 4 or 5 months after her birth.
1.5 years, my
I'll
lords.
assist your
After the birth of the
1.5
child,
year.
1.5 years.
and after
Yes,
that, who was taking care of her?
My lord,
We were,
immediately
my lords.
second marriage.
No.
Immediately the second petitioner, the first petitioner had a second marriage, and the child knew her. Even she was her neighbor. The foster mother now was a neighbor, and the child knew her since the young age. In fact, the petitioner's daughter also knew her. After a marriage, all along until the filing of GNWC petition, the child was residing and is still today residing with the petitioner. She is comfortable with the mother and father. But in fact, I've gone to your lordship decision passed in Telangana High Court, my lord. We cannot deny the right to grandparents. I am in totality agreeable, my lord. The child says, in fact,
Sir, a solution to a problem is not going away from the problem.
please, my lord.
We have to solve it, how
We
it
have
has
to.
to be.
In fact,
No,
Please.
the grandparents have to, and if what your apprehension and if that's a reality,
please.
the grandparents have to understand that whenever the girl is with them, they shouldn't do all those kind of things which you are apprehending,
Please.
and they should be made aware of it.
Yes, ma'am.
The solution is not that she should never meet the grandparents, because there is a likelihood of tutoring her and all. No.
Please. No, my lord. What is my instructions is, my
You
lord.
have to convince the girl, because definitely because the grandparents, they have lost the daughter. They want to definitely
That is the reason.
spend time.
That is
What is this 1 or 2 hours?
No, my lord, I can, in fact, my fair submission before lordship, I submitted, my lord, in fact,
Not happen from morning to evening, will happen in the night.
my lord, it is,
That is not, please get instructions from your client.
please, my lord,
And this can't go on like this.
I
And
will-
if
I
the
will-
grandparents are not,
I'll take
are not
instructions.
behaving in a manner which they are supposed to, then the court will tell them, will
Yes,
give them some, will give the visitation or interim custody for 1 or 2 days. We will see if they are doing, if they are behaving in the same manner, then we can look into
Please, that
that.
I'll
Malad,
seek instructions.
Malad,
on-
may I just point out, Malad? May I just point out?
Yes.
Malad, page number 26, Annexure A. That's the wedding card. That's the second marriage which the respondents have entered into.
24th April 2019.
24th April,
Please.
right, Malad? Malad, come to next page, Malad. Annexure B, that is
Now,
page
my lord,
27.
please, I'll take it. I do not want to.
May,
I
may,
have heard
Malad,
him.
What is
I let
happening,
him
my lord,
complete.
This is what is happening. We are trying to
Malad,
find a
I have,
solution. He's trying
Malad,
to create a
I have
problem
let
again.
him complete.
Now,
No, I'm not disputing.
Lordship is with
We
him.
also want an amicable settlement.
I heard you, we'll
Please,
also
ma'am.
hear him.
Please, man.
Yes.
My lords, if your lordship look at the dates of the medical receipts, my lord,
Page
we have
number.
page number 27 to
Mm.
May I
Page number
assist in
27
this,
to
lordship, my
39.
lord? This is a medical record that the daughter was ill, the ward in, was ill on 19th
my
of
lords, my lords,
2019. The marriage
let
was
him allow
1
me
week
to
later.
complete.
So his contention is that
My
when
lords,
the daughter was ill, he got married.
So what, yes, please come.
my lords, yes, exactly my point, my lords. His daughter was admitted in hospital. We informed him, but still he didn't care. I'm not saying that we want the whole custody. All I'm saying is look at his conduct. He didn't care when his daughter was admitted in the hospital. He went and got married. We have taken care of the daughter all along, the grandchild. And only when she attained, my lords, let me complete. Let me complete.
Why are you not letting
Let
him
me-
complete?
Please, my lord.
So, my lords,
Yes.
only when the daughter was eligible for going to school, he approached us. We said, okay, we are ready to. But they didn't even, they're not even allowing us to meet the child. They say that we are bad people. This has come down from the child's mouth. My lords, I'm not disputing. Whatever your lordship say, I'll abide by that, my lords. We don't mind. Whatever falls from your lordship, we are okay with it. But this is the conduct of the petitioners, respondents. This is the conduct of the respondents, my lord. Having lost the daughter, they don't want to lose the granddaughter, my lords. This is their only concern. We abide by whatever falls from your lordship, my lord.
23? What is today? Today's date is 17. 18, 19, 20 we have. 20? On 20th? It's not there. On 20th, heard the councils poses matter on 20th on the day. The grandparents, father
No.
and
20th, I have some personal inconvenience, my lord. Any other day, because I need to be there if the child is present, my lord.
let the parties come.
I have certain personal inconvenience. I'm on a pilgrimage.
No, your presence is not required. Court will only speak to them.
If they'll humble request, my lord, otherwise I would not stop.
On 23rd,
Please, ma'am.
24th. There, on 24th,
Please.
the father along with the child and the grandparents shall appear before the court in evening at 5 o'clock in the chambers.
And make one request, my lord. Out of the record, my lord, let him keep both the grandparents, because last time all around grandfather had not
Both
appeared.
the grandparents.
My lords, all the petitions will be there.
Yes,
I'll assure that all the petitions will be
yes, yes, yes.
there. Highly obliged. Highly.
Yes, next.
Cell number 3.
I'm for the petitioner in this case. This petition is for modification of interim order. Reduce the interim maintenance. The Honorable Family Court has granted 16,000 per month to the respondents, my lords.
You're the husband.
Husband,
What is his income?
he is agriculturist, my lord. He is.
What is the evidence before the court for granting 16,000?
based on some photographs and revenue documents produced by the
Look at
respondent.
it. Let's look at the order.
The respondents have produced some photographs and revenue documents. The Honorable Trial Court come to the conclusion that the petitioner is earning rupees 70,000 per month, my lords.
From sugarcane,
He
sunflower and vegetables.
yes, my lord, he has no income from the agriculture, my lords. He out of his meager income,
Have
is
produced
providing
photographs
all
from
medical.
Respondent's coconut garden,
My lords.
sunflower field and the RTC extracts. How much land you own,
Since the properties are joint family properties, my lords,
whatever it is? How many acres?
I don't know idea, my lords. All the properties are joint family properties, my lords. There is no partition between the family
No,
members.
if it is not also, you should know what is, have you not filed your statement of assets and liabilities
No, my lords. We will file
for the
it.
trial court?
Yes, we will
Why
file.
filed?
We will file it, my lords.
You have not filed, court passed an order, what is wrong in it? When you're given an opportunity to file your statement of assets and liabilities, you should have filed.
We will file it, my lords.
Then why should, it's not, we will file, you should have filed.
Yes.
Why should this court interfere? No, this is not an exercise like one after the other, the trial court will spend some time, again high court will spend some time, no. And again it will be remanded. Court's time is valuable.
Anyway, my lords,
And
he
if
is-
you have taken, if you're not, whatever is the remedy available to you, or you have given an opportunity, if you have not taken it, we will not come to your rescue. No stay, notice to the respondent.
they have pressured the petitioner to.
We can't do anything. This code is very clear on that.
Kindly stay,
Notice to the
stay the
respondents,
option.
petition is no stay. Petition is permitted to take out notice on the counsel appearing for the respondents and file a memo to the effect, pose this matter on 14th of October.
Bill number 4. Aditya D.
Appear for the petitioner, my lord.
Yes.
My lord, this is a case of restitution of conjugal rights, where an IA was filed for visitation of a minor daughter, my lord. Initially, the trial court gives a interim order for 2 hours every Saturday and Sunday. Subsequently, after hearing both parties, the trial court has said for 4 hours every Sunday, my lord, which is under challenge. The mode of visitation is either physical or video conference. In this case, my lord, kindly.
Put notice to the respondents, then we'll pass an order. Petition is permitted to take out notice to the counsel appearing for the respondent of the trial court. I shall file a memo to that effect. If the memo is filed on 27, post this matter on 30th.
My lord, can I also request for hand summons, my lord?
Hand summons. Notice is by way of hand summons.
Bill number 5.
For the petitioner in the connected matter.
Gerale.
This is a matter
Maya.
where interim maintenance, my lord, of rupees 10,000 a month and 15,000 towards cost was awarded by the trial court. That has been.
You appeared for whom, husband or wife?
For the wife.
You want enhancement?
I have sought enhancement.
Hmm.
The
They have
husband has
questioned
sought-
that order.
Question the order.
How much is, how much you have sought as maintenance?
Lord, I have sought, Lord, 60,000 per month.
Court had granted?
Court has granted 10,000, Lord.
Hmm.
And
What is the income of the husband according to you?
Lord, husband, Lord, according to me, he is owning properties worth 200 crores along with other businesses.
Your Lordship, if
What
I
is the, both of you file your statement of
No,
assets?
my lord, this is pre the statement, assets and liabilities regime. We will go, my lord, and file statement before the trial court. But, my lord, the only issue is this honorable court, my lord, stayed the order subject to deposit of 5,000 rupees before the registry.
That is
they
also
have-
not done.
That they have not deposited and they have not paid 15,000 cost of litigation also, which this court directed.
Your
to
Lordship,
pay.
we have been making the payments before the registry, Your Lordship. If I may be allowed to seek a consolidated memo on the
I have,
same,
my lord,
because I have
judicial deposit, the page pertaining to judicial deposit that is uploaded online. May I pass on?
Take that.
This shows, my lord, that out of 3 lakhs that had to be deposited by now, 1,90,000 is deposited.
Then we will dismiss your writ petition.
Please, Your Lordship, the matter was referred to mediation, Your Lordship.
Whatever it is, there is an order of the court which you are enjoying from when? 2020.
2020.
If I may be allowed, permitted to seek instructions, Your Lordship, any day tomorrow.
We'll post it tomorrow, tell your client, by tomorrow, by the time the matter comes, if that amount, what is ordered by the court is not deposited, first your writ petition will be dismissed. Tell him that. This court has directed the husband to deposit an amount of ₹5,000 by way of an interim order. On that condition, stay is granted and counts for the respondent submits that. So far, they deposited 1.5 lakh.
1,90,000.
19 or 90?
990.
1,90,000. Pose this matter tomorrow as a land counsel for the husband wants to get instructions. By tomorrow, if the amount is not deposited, then the stay granted by this court will be vacated and the writ petition shall be dismissed on that ground. Yes.
Number 6,
Yes.
Tyagaraja B.
Trial court has disposed the matter.
It is submitted that the MMO is filed stating that the main MC itself is MC or criminal
MCU.
MC itself is disposed of as the writ petition has become infectious, dismissed.
Till number 7,
Lord, MC was disposed of on 29/9/2022.
What is that?
MC petition itself was disposed of, my lord, on
A memo is filed stating that the MC itself is disposed of on
29/9.
29/9/2022. And no further orders needs to be passed on this petition. Yes, next.
till number 8,
Give
till
that.
number 8,
Respondent.
Kumar KG, Latif B.
When the matter came up on 24/3/2023, there was no representation on behalf of the petitioner. Today also, there is no representation. No representation. Post this matter for dismissal tomorrow. Yes, next.
Till number 9. Anusha Nandish.
Lordship, husband petition
Hmm?
challenging the interim maintenance. However, the MC petition came to be disposed on 39/2021.
39,
2021.
9/20. This is against an interim maintenance. It is submitted, no representation on behalf of the writ petitioner. Land counsel appearing to the respondent submits that the main MC itself is disposed of on 39/2021. As this impugned order is arising out of an interlocutory order, nothing survives in this writ petition. As the order has merged with the final order, accordingly dismissed as infructuous.
Till number 10 disposed. Till number 11. Jeka Shetty for petitioner. Harish MG.
For respondent, kindly press for some time, madam.
Where is the counsel for the petitioner? No representation for the petitioner. Counsel for the respondent is present. Pose this matter for dismissal tomorrow. Yes, 13.
Till number 12 disposed. 13.
Yes, give the file. This is a writ petition of 2021. It was last listed on 28/7/2021. Today on the matter is listed, no representative for the writ petition. Oppose this matter for dismissal tomorrow. Yes, 14.
Till number 14.
Yes.
This is husband's writ petition. The trial court has granted a maintenance of 7,000 rupees per month, my lord. 7,000 rupees per month.
To the wife. You are appear for?
I am for the husband. The petition. The husband is was a security man.
24. Have they not executed the order?
No, they are not executed.
What happened to these arising out of criminal miscellaneous or?
Civil miscellaneous. Section 24. I have filed a restitution of conjugal rights under Section 9 of the Hindu Marriage Act. Now,
These are an application that's arising out of an MC.
MC, please.
In the MC, you filed an IA.
The wife has filed an IA.
That's what.
Please.
So the MC is still pending.
Still pending.
Oh, no, it has to be ordered. Notice has to be ordered in a 2020, in the year 2020.
Notice served. They have unrepresented.
Please argue.
Please.
Please come to the
Served
order.
and unrepresented.
Please come to the order.
Please.
Where is the order?
At annexure, at in page 54, madam.
Yes. Please read.
Reasons, my lord, point number 1. The present application is under 24 of the Hindu Marriage Act by the applicant respondent against her husband, who is the opponent petitioner seeking interim maintenance pending litigation initiated by said husband, seeking dissolution of the marriage on the ground of cruelty. In this case, the fact that parties to the proceedings are legally wedded couple having solemnized marriage on 9/6/2004 is not in dispute, and is also not in dispute that the couple has a 16 years old child out of their wedlock. As such, the right of maintenance for the applicant respondent is inherent in the inception of the said marriage itself. However, having regard to the purview of present application, section 24 of the Hindu Marriage Act is concerned. The test is whether wife has an independent income sufficient to maintain support, and that she is in requirement of financial assistance to meet the expenses of the proceeding. In this connection, the respondent accepted pleading that the petitioner is a security guard with a salary of 25,000 along with an agricultural income, rupees 5 lakhs per.
The age of the petitioner?
47 now, madam. He is unable to work also. He is now going for coolie work, madam. He has a dismissal from security when he was during a COVID period, madam. Whereas she is working and drawing a salary of 15,000 rupees. And I have got my mother. I have to look after my mother also, madam.
You have to look after your son also.
Her son, yes, he's a major now, of course. Now he's a major. And from 2000,
from when he has become a major?
Major now just 1 year. 1 year.
1 year back. So anyhow, till such time you have to pay.
My submission is that, my lord. I even I have no work, but however some coolie work I have done here and
Till
there.
now you have not paid any amount to them.
So far, not. It is a permanent alimony granted by trial court, section 24, not a member interim maintenance. This is a restitution of conjugal right, my lord. I am ready to take back her. So question of maintenance does not arise. In spite of that, she filed section 24 first time. So far, they have not. She has not filed any interim application before any court.
This is an IA filed under the.
IA filed.
In MC.
Yes. No, the 7th, actually 24th, she has filed an IA.
Yes.
My submission is that in so far as 24 is concerned, capacity of the spouses has to be looked into, my lord. In this case, she is working. In fact, I have no fixed source of income. 7,000 is ordered.
What is the evidence before the court that she is earning?
I have filed my affidavit stating that she is earning, and I have.
Not affidavit. You can say, she also can say so many things. But what is the material before the court that she is earning?
Main matter is for restitution of conjugal right, my lord. Now the interim application only
asking restitution of conjugal rights, but she has her own difficulties. Why she is not able to come back? She has her own reasons for that. Now, as far as maintenance is concerned, according to you, she is working.
Please.
That's what you are saying.
Please.
What is the evidence placed before the court in that regard, except your assertion in the affidavit?
Please. That is the only, because it is interlocutory stage, my lord.
You have not reduced any other evidence.
The trial court has not recorded any evidence. Only on the basis of the objection it has passed the order. Actually, inquiry has to be conducted in view of the dispute between the parties, whether I have got capacity to maintain her, or whether more income she is drawing. At least minimum inquiry is necessary. No, only on the basis of the objection.
You have forgot about the wife.
Please.
You have a son. You have to maintain him.
Please.
No, it is for both son and wife, or
only for a wife and including son and Chalida. She has filed, including son, but she only filed application.
No, that's what on behalf of son also.
On behalf of son.
Application filed by so and so, maintenance including herself and a minor son.
A minor son. Now he's a major, man.
Till from the date of order till he has become major, you have to pay.
Please, that is true. But so far as 7,000 is concerned, my lord.
So how much you will pay?
The thing is very difficult, and I am getting coolie work, my lord. Some reasonable reduction has to be made. That's only.
What is the reasonable reduction? 1,000?
No, not 1,000. At least 4,000 or 5,000.
5,000 will make.
Please.
Please come. Agreed with the orders passed in I number 1 in MC number 9 of 2020, dated 21/4/2021. The husband is before this court. The respondent herein, MC is filed by you.
MC is filed by me.
MC number 9 of 2020 is filed by the petitioner herein, seeking restitution of conjugal rights. In that, wife had filed I number 1 under section 24 of the Hindu Marriage Act, seeking interim maintenance of an amount of rupees 30,000 for herself and her minor son. It is a case that the petitioner is working as a security guard and earning an amount of rupees 25,000 per month. And because of the harassment by the petitioner, she had to leave the matrimonial home. And he's also having agriculture income and is having more than 5 lakh per annum. And works as a manager in a picture talkies and earns rupees 30,000 per month. And despite having the income, he's not maintaining the wife. The husband has filed his objection stating that the wife is earning, is doing coolie work. He is not in a position to work because of the health conditions. He has to take care of his mother who is having ailments. The trial court had granted maintenance of an amount of rupees 7,000. While granting the maintenance, the court has observed that in an application like this, the court has to find out whether the respondent has sufficient source of income to maintain herself. Whereas no such material is forthcoming before the court to say that the wife is capable of maintaining herself and the child. And the court observes that it's a bounden duty of the husband to maintain his wife and children. Though the wife had not proved exactly what is the income of the husband, it would be just and proper to grant reasonable interim maintenance along with litigation expenses in order to facilitate the wife and a minor son to lead a dignified life. Accordingly, an amount of rupees 7,000. What is this, 7,000?
7,000 to the respondent, including her son from the date of
Hence, it would be just and proper to order in lump sum. Expenditure is in total 7,000.
Litigation expenses.
Expenses is 7,000 and 6,000 is interim maintenance.
Hello. Litigation expenses 6,000. The petitioner also liable to pay litigation expenses total 6,000.
Read it, page number 61, bottom 4 lines.
Please.
Hence. 61.
61, sorry.
Yes.
Yes. Lump sum, the pendant like expenditure.
Hence, it would be just and proper to order.
It would be just and proper to lump sum the pendant light expenditure in total 7,000 and 6,000 per month as interim maintenance to the
So
respondent.
what the court said is 7,000 is litigation expenses, 6,000 is maintenance.
Yes. Actually, 7,000 maintenance, 6,000 litigation expenditure. At the operative portion, it is there.
The court had granted 7,000 as maintenance and 6,000 as litigation expenses. Next para. The notice is served on the respondent. No wakalat is filed on her behalf. Land counsel, next para. Land counsel appearing for the petitioner, husband submits that the petitioner is doing coolie work. Now the son has also attained a majority. The wife is working. All these aspects were not considered. When the husband has taken a plea that the wife is earning, the court should have conducted the necessary inquiry in that regard. And without any basis, the court had granted the amount. It is submitted that he has to take care of his mother and has to take care of his health. And also both of them are having health ailments. And it's very difficult for him to pay maintenance of an amount of rupees 7,000. Next para. This court having heard the land counsel for the appellant petitioner This court has perused the order passed by the trial court. Except stating that, except the wife had stated several things like he's having working as a security guard, working in networking, and also is having agriculture income, but there is no evidence in that regard. The court had granted 7,000 as maintenance and 6,000 as litigation expenses. Considering the fact that he's working as a coolie, the coolie, this court deems it appropriate to reduce the maintenance from rupees 7,000 to 5,000. The petitioner shall pay the amount of arrears at rupees 5,000 from the date of, it's from the date of petition. From the date of petition till today, within a period of
4 weeks.
4 weeks.
But
Accordingly, the petition is. Yes.
Till number 15.
Time, my lord.
Lords, already.
1 week
matter
time,
is
my lord.
Disposed of.
Let's see.
Trial court has already disposed of the matter in criminal miscellaneous 149.
It's already disposed of.
Please.
Then what remains in this?
Senior instruction 1 week time, next week,
Senior instruction.
RPFC in my lord, 2 cases. One is RPFC, 1 file.
Please understand. This impugned order is arising out of what?
Criminal miscellaneous 149.
Criminal miscellaneous 140.
Kindly pass our instruction, senior.
Yes, please get instructions. Tell your, if that criminal miscellaneous is disposed of, nothing remains in this.
No, my lords, I would make one submission.
Yes.
Based on the criminal miscellaneous 149, that it will be disposed of. Subsequently, of the order has been passed, the final order has been passed, they have challenged it before the RPFC, before this same honorable.
Then what remains in an interlocutory application?
It is-
Get
it becomes
instructions,
infructuous.
pass over, pass
Please.
over.
Till number 16, Sunil Shastriyam for petitioner CG Malayil.
I appear for the petition in this case, my lords. I seek 1 week's time.
Right.
Senior is not in the stations.
What is, what?
A date may be fixed, my lord.
What
There
is
no
this
objection.
matter? What is the impugned order? Let us see. In this GMFC matters, whatever, what is, you can argue why senior is required.
Lords, arguing counsel is not in the state. That is the reason, my lords. Arguing counsel is not.
heard by the judge.
No, my lord, but prior to hearing of that matter, the same order has been challenged by the petitioner in 2000, back in 2015 itself. So now the matter which was remanded back to the deputy commissioner, the same has not been heard because the same has been challenged here.
No representation for the appellant. Post all these matters for dismissal tomorrow.
Please, ma'am. Grateful.
Cell number 26. G.S. Venkat Subbarao for appellant. S.G. Hegde.
Yes.
26.
Yes.
It is defendant's appeal
Yes.
against my lord grant of an order of temporary injunction. My lord, the first respondent, who is the plaintiff before the trial court, but files a suit for my lord declaration and other reliefs, contending that my lord, he is the adopted son of one L. Shankar Raju. My lord, Shankar Raju is our elder brother. My lord, he was issueless. My lord, that thereafter, my lord, being class 2H, we have succeeded to the property. Is the pith and substance, the defense that we have put forth before the court. My lord, his claim, nevertheless, is
What
my
is the
lord,
injunction he sought?
the injunction, my lord, he sought, my lord, we should not create third-party rights in the property. And that, my lord, he claims to be in possession of some property, for which, my lord, we should not obstruct. But assuming that, my lord, he also becomes his adopted son, until, my lord, it is divided, or, my lord, the court declares him to be, my lord, the absolute owner of the property. We, having succeeded to the estate, my lord, we are entitled to use, my lord, if we are in possession of the property. Then none of these contentions are addressed by the trial court. Court grants an order of injunction that, my lord, we should not obstruct his possession.
So what is the evidence before the court that he is in
My lord,
possession of the
he,
property?
my lord, he places some school records, my lord, which cannot be of conclusive proof.
That adoption issue and all will not go into.
Yes, my lord, that
About
is
his-
something that.
About
yeah.
his point.
Yeah.
Even not to create third party rights also, unless that order is there.
Please, ma'am.
it can't- No, only to that effect, the order with regard to the injunction.
Yeah.
What is the material before the court?
But page 22, my lords would get, my lord, how the discussion has gone back. Lord, I may submit that, my lord, the learned trial judge has aired in fundamentals. Lord, the point number one that is raised for consideration, my lord, we have been taught, my lord, even in law schools, that, my lord, prima facie case, balance of convenience, and my lord, hardship.
Let's read the order. Please read the order.
No, that is not considered by the trial court. It doesn't even raise a proper point for consideration. At page 15 onwards, para 12, my lord, the discussion starts. Otherwise, my lord, until from page 9, para 9 to 11 is, my lord, the contentions of the parties. May read, my lord, para 12 for my lord's concern.
So is it his case that in respect of item number 1 to 3, late L. Shankar Raju was in possession of the property?
It was his absolute property.
When did he die?
No,
When was the death of that person, that Shankar Raju? Date?
yeah.
Let's go to the plaint. Where is the plaint?
Plaint, my lord, was not placed before the court.
That is relevant.
Yes, my lord. But earlier it was not placed before the court.
You have a copy of it?
My lord, I do have a copy.
Yes, if you have a copy, pass on.
But 11/7/2006, my lord.
Certified copies.
11/7/2006 he died, my lord.
11/7,
Yes, it is in the
2006.
6. It is stated in the impugned order also, it is mentioned.
Please, let's understand what is this case. Please come to para number 8 of the plaint.
Yeah, my Lord, I seek apologies. That was the only copy I had.
You have a copy
Sorry.
of the plaint.
Yes.
What is this voice number 438 of 2000?
That was filed by us, my lord,
Seeking?
seeking declaration and my lord, in respect of the properties.
What is
That,
the
my lord,
claim
is,
that is
that
sought?
is, that is sought to be attacked, my lord, being collusive. My lord, be that
You filed a suit, voice number 438 of
2015, yes.
seeking declaration that
In respect of the suit scheduled properties, my lord, the declaration was sought. That was against my brother. And my lord, that, my lord, is, my lord, is, that the matter was squared up, my lord, and matter rested there. After that,
happened to that suit?
no, that was disposed of, my lord. That is disposed of. That, my lord, the plaintiff
That suit against whom?
against my lord, Shankar Raju and other persons.
On the ground?
On the ground that, my lord, it was property that belonged to the family. So, my lord, that, my lord, entered,
Suit, it's a declaration.
it was declaration, it was not a partition suit.
Oh.
My lord, that, my lord, my lord, decree was entered into, my lord, that now the plaintiff claims that, my lord, it is a collusive decree. My lord, be that as it may. In order to, as my lords observed, his right prima facie emanates from, my lord, two things. One is adoption. Unless, my lord, that is, my lord, something to be thrashed out at trial. Unless
First of
that is,
all, there is no dispute about the fact that this
Please.
person, that Shankar Raju, is the owner of the property. It is not a joint family property. No,
yes.
you succeed to the property, or the plaintiff will succeed to the property, has
To be decided in the
by the
trial.
court.
Correct,
Now,
please.
admittedly, that is in possession of Shankar Raju and his wife.
Yes.
And his wife died in the year 2012.
Please.
Now from, that's what I wanted you to read at para number 8.
Please.
He also says that in respect of the residential property, he has been paying the taxes. Mutation is in his name as on the date of the filing of the suit. Itself shows that he is in possession of the property, prima facie.
Mere,
The court might not have given a prima facie on that, but
That's-
still it has to be decided. It should be decided.
now that, my lord, after the appeal being filed, Lord, this honorable court has, my lord, kept both the parties under status quo. Same status could continue, my lord, that suit could, my lord, be decided on merits in a short span of time. However, my lord, there is an order.
Status quo is the
I understand, my lord, that, however,
biggest problem.
And
It should never grant a status quo
however,
without saying who is in.
order, my lord, is in existence for about 8 years. So, right, same status could continue, the suit could be disposed of.
Let it be status quo. Let
No,
it to
status
remain.
quo, this honorable court clarifies that we are in possession and a status quo to be maintained, no problem.
No, all the while it was there. There was no clarification by the court.
No, regarding the injunction.
Time of admission, let's see what the order passed by the court.
Injunction is granted. It's not status.
Not
Status quo, he says.
29/9/2016.
29?
9/2016.
Kindly see, my lord, the defend number 1.
Parties are directed to maintain status
Status.
quo as on today.
Please.
In respect of the scheduled property and until further orders. So it's been continuing from 15 to 24.
But
Have you filed your vacate petition?
no,
One submission, I'll just look at it.
Please look at 29/9/2016 order.
That, of course, that order I'm not having. I will come back to court.
No, nothing. There's just a 4-line order, no discussion. Simply parties are directed to maintain status quo as on today. This is the only order, nothing to.
Yes, ma'am, there's the
4
order
lines.
passed by this honorable court. Now the question is, my lord, the injunction is there in my favor. Injunction is not in my favor. Suppose the state to be interpreted as status quo, then again they start interfering with my possession. then the issue, again, there will be list.
They must have done by this time.
Pardon?
They must have done by this time.
No, question is, my lord, now suppose if it is said it is continued as so. Then again interpretation comes, who is in status, so under who's in possession. Now the trial court has examined the papers.
What is the stage of the trial?
Pardon, now I think.
Stage of the trial
evidence,
now?
I suppose, evidence, I suppose.
Evidence is completed.
It has to be started. Just I'll certainly, my lord.
Then instead of the status quo, let's see on the merits of it. Now, what is your case? What
My
is your
case is,
case
my lord,
with regard
soon
to,
after, my lord,
what is your case with regard to your position? Let's see the written statement.
Yes.
What is the suit schedule property?
there are four
Three
items.
items.
Item number 1 is house property. Item number 2 is also a house property. 3 houses.
Yes.
4 is also house property.
5 is agricultural land, of course. In one of the properties, he's staying there. If the status quo and if the injunction is not granted, can you see the cost
I
account?
submit that the plaintiff number 1, after getting the kata change in its name out of love and affection, has gifted IA scheduled properties in favor of me by gift deed dated 15/9/2014 and 25/2015. The same are registered in the office of sub-registrar and I accept the said gifts. Since then, I am in full possession and enjoyment of the properties, as it is absolute owner. Even before you file the suit, by the time the properties are registered in favor of somebody else.
Yes.
That was as per, my lord, the decree that was passed in MOS 438
No.
of 15.
No,
I'm-
it's a gift.
It is voice number 6029, that's a present suit.
Yes.
Now, in the present suit, plaintiff number 2 has filed an affidavit stating that there was a gift deed by plaintiff number 1 in favor of plaintiff number 2 on 15/9/2014.
That was prior to suit, Right.
Prior to suit.
Right.
Please come. The present appeal is filed. Agreed with orders passed in I number 1, 2, 4, and 5 in OS number 6029 of 2015. Dated the 8th December 2015. The appellant before this court is the defendant number.
My lord, 1 to 3.
Represent all the defendants.
1 to 3.
Defendant number.
There are other defendants.
Defendant number 1 to 3. What about 4 and 5? They are served.
5, yes. We have sought dispensation because
You
they were
sought dispensation.
co-defendants. Yes. They were co-defendants. Injunction between me and the plaintiffs, therefore.
One is already dismissed.
No, notice to R3 dispensed with
Done. Again, SR1 is
by the order dated so and so. Appeal against R1 is dismissed.
There is none other than.
Now come to the cause title of the appeal.
Plaintiff.
These are defendants 1, 2, 3.
Yes,
R1 is plaintiff number 1.
please.
Why the appeal is dismissed against plaintiff number 1?
But, he's said to have died, my lord, and we made a substitution.
That was not innocent.
R1 died pending appeal. Pending appeal.
Is, I think, pending appeal. Into the date, I don't know.
Appeal against R1 is dismissed.
Yes, madam,
When
10
is
to
it?
23.
Huh?
10 to 23.
He died in 23.
10 to 23.
She is the legal heir. She is the only legal heir. Our
Yes,
plaintiff
only
number
legal heir, but they did not make any mention before the court saying that. That's why against R1, it was step was not taken as dismissed. But is it otherwise that R2 is the legal heir, she is on record.
We found out in the trial court also, my lord, no steps were taken being the plaintiff. That's how, my lord.
Land counsel for the respondent number 2 submits that respondent number 1 has passed away on 10/2/2023. And his legal representatives are to be brought on record. Hence, land counsel for the appellants to file necessary application to bring the legal representatives of deceased respondent number 1. This order was passed on 19/6/2023. Then you sought time for taking steps.
Yes.
Yes, you have not taken any steps to bring the LRs on record.
Yes, my lord, I'll verify, my lord, my instruction, because I'm not there in the trial court. My instructions in the trial court, that itself, my lord, there is no substitution, what I'm given to understand. That's how.
No, he died pending the
Pending appeal, pending appeal. Suit is never, in suit itself, my lord, substitution has not occurred is what my instructions are. Now, our, my lord, my lord, probably secure, my lord, take instruction, my counterpart in the trial court, my lord, probably. My
At
lord,
least before arguing this matter, both of you should clarify it. Unnecessarily, I'm hearing it from the last 20 minutes.
Submission, my lord, they could have made a submission. One of the legal heirs present for the court as plaintiff number 2. As
Court has already granted sufficient time.
But they did not make any arrangement for that.
Right from 2023, this is all happening. So many times the matter is listed. 2 weeks' time is granted to the needful. There is no representation. 1 week time is granted to do the needful, failing which the appeal against respondent number 1 shall stand dismissed. That's how it is stand dismissed. Against respondent number 1. Then what remains?
However,
Your appeal is dismissed against respondent number 1.
plaintiff number 2, my lord, also, my lord, estate gets sufficiently represented, my lord, that's the only submission I could make now, because he is a co-plaintiff.
Anyhow, we are dismissing your appeal, doesn't matter. Yes, what is that? This court, the first respondent, the first respondent in the appeal, that is a plaintiff in the suit, died on 10/2/2023. Thereafter, the matter underwent several adjournments and the appellant failed to take any steps. Hence, appeal against him is dismissed for appeal against the first plaintiff, that is the first respondent, herein is dismissed. But as far as the third respondent is concerned, a memo is filed stating that the notice to be dispensed with or a substitute service.
No relief sought.
Notice to, as no relief is sought against the respondent number 3, notice to R3 is dispensed with and R4 is represented, R4 notice is served, but there is no representation. The second plaintiff, that is the respondent number 2, is represented by advocate. Next, the appellant herein is the appellants herein are the defendants 1 to 3. The first respondent herein, the respondents 1 and 2 herein had filed an appeal, had filed a suit seeking the relief of declaration that he is adopted son of late L. Shankar Raj, to declare that the judgment and decree passed in voice number 438 of 2015 on the file of the Additional City Civil Judge, Bangalore, obtained by defendant number 123 in respect of the suit scheduled property is null and void and not enforceable in law, and the same is not binding on the plaintiffs. And also he has sought for a relief of cancellation of the registration of the said decree registered in the office of the sub-registrar with direction to effect the cancellation in the records of the sub-registrar, grant a decree of permanent injunction restraining the defendant from interfering with the peaceful possession and enjoyment of the property of item number 1 to 3 by plaintiff number 2. It is a specific case of the plaintiff that he is the adopted son of late Shankar Raj. He was born on 12/3/1983. He was given in adoption by his generic father with the consent of the mother on 12/3/1985. On the same day, the L. Shankar Raj, along with the consent of his wife, accepted the plaintiff number 1 as his adopted son, took him into their custody. He has been, the late L. Shankar Raj has brought him up as his adopted son and gave him his education at Bangalore. He got him admitted to the school at SDM High School at Jalahalli, West Bangalore in the year 1989, describing him as his son, and he has studied up to 7th standard in the said school. Subsequently, he joined Rajarajeshwari High School and completely studied up to SLC in the said high school. In the records of the high school, also, the name of L. Shankar Raj is mentioned as his father. His name is also included in the ration card issued by the Food and Civil Supplies Board, describing him as his son. And also declared him, his name is, name finds place in the voters list maintained by the BBMP and the electoral card issued by the Election Commission of India, and indicates the name of the plaintiff as the son of L. Shankar Raj. Right from 1985, the plaintiff was living with his adopted father and was brought up and educated by him. His adopted father died on 11/7/2006. The compensation which they have received was donated to the ISKCON for the purpose of meeting certain pious obligations. In the said records also, the name of the plaintiff is shown as the son of late L. Shankar Raj. The mother died on 28/2/2012, leaving behind the plaintiff as his only legal heir, and he has become the absolute owner of the estate left by the deceased and his wife. And ever since he has been in possession of the property. He had, after the death of the adopted mother, he got change of khatas in respect of the self-acquired properties in his name in the office of the BBMP Bangalore, and he has been paying the property tax regularly, and he has paid the tax up to date. And the plaintiff, being the absolute owner, had bequeathed item number 1 to 3 of the scheduled properties in favor of his wife, plaintiff number 2, out of love and affection, by registered gift deed dated 15/9/2014 and 25/2014. And the plaintiffs 1 and 2 are in actual legal lawful possession and enjoyment of the property. It is a case of the plaintiff that a collusive suit has been filed, that is OS number 438/2015. And they have obtained a decree in respect of the 2 scheduled properties by suppressing several material facts. as such has come before the court seeking a declaration that the said decree is not binding on him. In the suit, he has filed the IAS seeking an injunction restraining the defendants from any third party interest and also restraining the defendants from causing obstruction to the peaceful possession and enjoyment of the property. So in item number 1 to 3, pending disposal of the suit. And they filed IA number 4 and 5 under order 39 rule 4 CPC. IA number 4 and 5 is filed by the defendants under order 39 rule 4 CPC to vacate the interim order passed by the court earlier on 25/7/2015 on IA number 1 and 2. The trial court had granted the relief not to alienate and also an injunction restraining the defendants from interfering with the possession of the plaintiff. While passing such an order, the court has observed that it is not in dispute that the suit property item number 1 to 3 or the self-acquired properties of late L. Shankar Raju. After his death, plaintiff number 1 has succeeded to his properties. From the documents produced by the plaintiff, it is made out that the suit properties item number 1 to 3 are gifted to plaintiff number 2 by her husband, plaintiff number 1. And they are in possession of and they are in possession of the property. The defendants 1 to 3 had filed the suit against the defendant number 4 and 5, that is OS number 438 of 2015. In the said suit, they have not made parties the children of late Chamamma. The court further observes that there is a force in the contention of the plaintiff that the decree obtained in the said suit is collusive. The court came to the conclusion that the plaintiff had made out a prima facie case for grant of temporary injunction and the balance of convenience is in their favor. And the injunction is not granted in favor of the plaintiff. Irreparable loss will cause to the plaintiff, which cannot be compensated in terms of money. And accordingly, dismiss the application filed by the defendant. Aggrieved thereby, the defendants are before this court. Learned counsel appearing for the defendant submits that whether as the late Shankar Raju is died issueless, and the defendants being the family members, and the property they are entire the property is devolved upon the other family members. Whether the plaintiff is adopted son of the son or not has to be decided by way of a full-fledged trial. The learned counsel submits that the court has also not given any finding with regard to the prima facie case. Unless and until there is a prima facie case, the court cannot grant injunction. It is submitted that the court, without the plaintiff, without satisfying the basic ingredients for grant of injunction, still the trial court had granted injunction. It is submitted that already there is a decree in their favor in the earlier suit that is filed. And all these things were not considered.
The points that were raised for not as is required to be raised in an
The
application.
point that were raised for consideration is whether the plaintiffs are entitled for the relief of a temporary injunction as sought for in IA number 1 and 2, under the application I number 4 and 5 filed under order 39 rule 4 CPC are liable to be allowed. It is submitted that the basic points were not the court had not framed the points for consideration. And the conclusion that is arrived at by the court is contrary to the settled law. Next para. Land counsel for the defendant plaintiff submits that they have been in continuous possession and enjoyment of the property after the death of Shankar Razu and his wife. And in support of their case, they make out a prima facie case, considering all that the court had rightly granted injunction. No, before that, land counsel for the petitioner submits that this court by order dated 29.
26,
26
29/9/2016.
29/9/2016 has granted an order of status quo as such. With the said order is continued pending disposal of the suit. It would serve the purpose. Next, land counsel for the continuation for the respondent plaintiff submits that he has been in possession of the property and there is an injunction granted by the court. Under the guise of the status quo order, the plaintiff would interfere with the defendant would interfere with the position of the plaintiff. Hence, there needs to be a finding by this court whether the order passed by the trial court was in consonance with the facts and the legal position. He submits that the court had considered all the aspects and parts in order, and no grounds are made out seeking interference of the court. Well considered order passed by the trial court. Next part. Having heard the counsels on either side, there is the material on record. The case of the plaintiff is that he's an adopted son of one Shankar Raju. And in support of it, it has been stated that he has been educated in Bangalore. He was joined in several schools. The ration card, the election card, and all other basic details mentions that he is the son of late Shankar Raju. It is his case that the Khata has been changed after the death of his adopted mother in the year 2012. And later he has also executed registered documents in favor of registered gift deed in favor of his wife in the year 2014 and in the year 2015. He is also paying taxes. As argued with the land counsel for the petitioner, for the appellant defendant, whether the plaintiff is the adopted son of late Raju and whether he is entitled for the share of the property will be eventually will be decided by the court during the course of trial. Prima facie, the material that is filed before the court of later so-and-so, and the Khata, there is the documents that are issued, the tax that are paid by the plaintiff, prima facie shows his position in respect of the suit property. The trial court had considered all these aspects and he has made out a prima facie case for grant of injunction. The reliefs that are sought is not to interfere and not to alienate. The trial court had rightly granted both the reliefs as the plaintiff had made out a prima facie case and the balance of convenience lies in his favor. If the injunction is not granted, it would cause irreparable loss to the plaintiff. In that view of the matter, this court finds no reasons to interfere. Accordingly, appeal is dismissed.
Cell number
Suit
27.
to be disposed of, my lord, uninfluenced.
Suit of 2015.
Yeah, no, my lord, uninfluenced by, my lord, the observation.
2015.
Yes, ma'am,
As
2015.
it's a suit of 2015, the trial court shall dispose of the suit as expeditiously as possible, but not later than 6 months.
Right.
27.
My lords, in this
Another
matter, I
zero.
pray for a week's time, lords, because my kids have come, but
Why in a 2017 appear a week's time?
some personal inconvenience to my senior because of.
Lord, I have-
So let's see the document. What are the earlier orders? When has it come up?
It came up last week and there was a peremptory order passed by your lordships.
Last week, my lords, the appellant sought for time. Today, some
Huh?
inconvenience to my senior. That is why I'm requesting your lordships to kindly have it Friday or next week, my lords. In the meantime, there are certain documents that are in Kannada. I should produce the translated copies of them. In the meantime.
Lord, in this case, what has happened is there is a suit and a counter suit. I am the developer of a property
about 4 acres, 30 guntas in Pudi, Krishnachpuram. My lord, I had commenced construction of a multi-storied residential apartment complex on my property. The total extent of the property was 4 acres, 30 guntas. Northern side of my property was Whitefield Main Road. After that, 4 acres, 30 guntas. I was putting up construction on my property. They came and interfered. My lord, they claim that to the south of my property, there is a land measuring about 38 guntas, 28 plus 10. Lord, to the south of my property, there's a buffer zone. And after that is, Lord, the lake area.
Yes.
So that firstly, there could be no property between the edge of my property on the southern side and the lake boundary because it is buffer zone. A. B. His vendor did not retain any land for himself because that both of us are claiming from the same vendor. My title goes back to 1985. In 85, my lord, his vendor put 4 acres, 30 guntas into a partnership firm. And the partnership firm was dissolved. And from the dissolved partnership firm, my lord, I have acquired the property, A, by sale and B, by way of registered joint development agreement. So 4 acres, 30 guntas that was in possession of his vendor under the partnership deed right back in 1985. That is now the land that is being claimed by me. The one of the
Has granted injunction.
Tryon Court had granted injunction.
Not to create third party, right?
No, not to interfere with the construction. In my suit is for bare injunction, my lord. I said, please don't interfere with my.
Their suit is for
No, no,
declaration.
I'll just come to that. His suit was for a declaration. My suit was for injunction not to interfere with the construction. My lord, I had the benefit of an injunction for 3 years before the trial court. On 19th of June 2017, the day before I filed this appeal, my lord, the injunction was vacated in my suit. On 20th of June, I filed the appeal before this court and obtained an injunction before this court.
Continue.
And in 2017, it was extended till further orders.
Then what's happened?
Now, in their suit, this is interesting. Their suit for 38 guntas, where they claimed that I was encroaching upon their property, but at some stage, they realized that it's not possible to continue to prosecute that suit by saying I am on their property. Therefore, they amended the relief to say that give me back possession of the property.
Recovery of possession.
Recovery of possession. So they amended the suit for recovery of possession and for declaration of title of that area. So they made it A and B schedule. A schedule is the entire property. B schedule is for recovery of possession. Now, evidence has commenced in the matter. Suit is going on. I have the copy of the amended plaint. So the question of nothing will arise. Construction is almost completed, my lord, as far as my apartments are concerned. Your lordship may expedite the suit because I've had the benefit, virtually, my lord, I've had the benefit of an interim order now for the last almost 10 years, my lord, from 2014.
No, he's denying your title to the property.
Pardon?
He's denying your title to the property.
No, he is asking for his title. He's not denying my title. He's saying I'm in possession of extent of land.
He says that 45 guntas or 35 guntas, whatever you're saying, according to him, he is the owner of the property.
Yes.
So he has purchased the property and he seeks a declaration and recovery of possession. That means in respect of 45 guntas of
38
land,
guntas.
38 guntas of land, he is denying your title to the property.
Maybe, my lord, I will take a chance because he has asked for declaration. If his suit fails, my lord, I must succeed. It's the same 38 guntas.
Kindly have it Friday.
Pose this matter on Friday.
Lord, would your lordship have it next week, my lord? Someday next week, any day, my lord. 25th, 26th.
30th is the last working day.
26th, 27th.
20, any matters are there on 27? 27.
Please.
Yes.
What? 27th, my lord?
28,
27.
29.
Yes.
28 adjourned, 29 disposed.
This is ours.
Cell number 30.
Yes.
Yes, filed memo for it.
So in this matter, my lords, in the morning, my learned friend had produced a memo. Only one submission, my lords. The suit in the trial court has been dismissed for non-prosecution, my lord. We will be filing necessary petition for restoration of
Dismissed
4th of September, my lords.
recently.
Please, my lords. So we will be filing necessary application.
Post matter 30 and 38.1 on November 11th. Any interim order in this?
No, my lord. No.
Post on November 11th at the request of land counsel for the appellant.
My lords, I appear for the advocate on record in this matter, my lords. I'll be filing my,
Whatever you want to do.
NOC Vakalat and
Yes,
file for
please.
retirement. My learned friend will take it forward.
Please.
You'll do on, yes, next.
Obliged.
Cell number 31. 31 urgent, 32 urgent, cell number 33. Narasimha Raju.
Appellant. And this appeal is against the government. And the allegation that towards southern side, my property, the government has encroached, sued for declaration, and also sought for possession of 1.14 guntas. 1.1/4 guntas. That was encroached by the government towards southern side of my property. It is clarified.
How they
This-
have encroached it, what is there?
Not just only they have fenced it, only a small fencing is there. There is no construction as such. It was clarified and it is admitted. It was clarified in the survey.
Has this come up before also?
Please, my lordship, it already is come up before lordship only. Lordship has directed to file some certain translated copies that
You
I
have
filed it, filed
filed,
it.
huh.
But
Yes.
that is, it is not this honorable court. Once again, Lord has directed to conduct a survey. Survey was conducted on May of this year. And in the report also submitted, the report also clarifies that they encroached 1.14 guntas of my land, the government. Thereafter, this honorable court has granted an order of status quo.
Where is that, where are those reports?
Reports, the
No.
government,
All these were not available before the trial court?
no, it was available.
Let's
One
come-
report
no,
kindly
What
come.
we do is, we look at the order passed by the trial court, then we will go to the other
Please, please.
material.
Let,
Please come to the reasoning part, we will see
please,
from
please.
reasoning.
It is in page 19, madam.
Yes. Yes.
Para 12 onwards.
Hmm.
Admittedly, the suit filed was filed by the plaintiff and the defendant for declaration and permanent injunction. It is not permanent injunction. So, declaration and recovery of possession. For declaration that the plaintiff is the absolute owner of B scheduled property and consequently direct the defendant authority to hand over the possession of the said property to the plaintiff. It is further paid for the grant of permanent injunction restraining the defendants or agents or anybody claiming under from developing or creating any third party's interest over the B scheduled property and other consequential reliefs. The case of the plaintiff is that she is the absolute owner and lawful possession and enjoyment of a bearing certain number 12/1A measuring 7 guntas situated at Abbigere village, Yashwantpura village, Bangalore North Taluk, having acquired the said property by virtue of the registered partition deed dated 17/4/2006, as a doc number so and so sub register. Subsequent to the acquisition of the property, Revenue Authority effected the mutation in the name of the plaintiff, Yamma Wide Yamma 24/2008, and according the plaintiff is in possession and enjoyment of said property. Further, plaintiff also moved for conversion of the land before the Deputy Commissioner, and on a request, the Deputy Commissioner, Bangalore, conducted an inquiry and then passed an order of conversion, accorded permission of the conversion of agricultural residential purpose, wide order of conversion dated so and so. Further, aware that the consequent upon the order of the conversion, since the property lies within the jurisdiction BBMP, plaintiff also paid a development charges to the BBMP. Thereupon, BBMP authority also issued a khata in the name of the plaintiff, and she is in possession of the said property. Further, she also paying tax to the BBMP continuously. It is stated on 12/15/2000 at about 9:06 AM, the plaintiff received the information of public at large that defendant authority trespassed into the property of the plaintiff and started to level the portion of the plaintiff property along with the local police. Immediately after receipt of the information from the public at large, she rushed to the spot and questioned about the legal trespass of the defendant authority and requested him to not to indulge any illegal activities. During that point of time, the third and fourth defendants have canvassed that the property which was enclosed by the defendant authority belongs to the government. Since Survey number 13 belongs to the government, which is adjacent to the southern portion of A scheduled
Please
property.
come to para number 17.
Please. None. The plaintiff A scheduled property is stated in agricultural land to an extent of 7 guntas in survey number 12/1A of Abbigere village, which is alleged to be the property of the plaintiff acquired by or through registered partition. In support of the same, she has produced a certified copy of the partition deed dated 17/4/2006, but the scheduled property shown in the property allotted to the share of the plaintiff is shown as in the property survey number 12/1A of Abbigere village. The same is reflected in form number 10. In B khata, extra survey number is shown as 12/1A, but in the tax paid receipt is shown as 12/1A, 1A7.
But again, the encumbrance certificate,
Ultimately, what is the property? Which is the property?
12
by
bar 1A, madam. My proper 12 bar 1A5 is the total,
5.
1A5 is the total extent of 2 acre, 15 guntas.
Please read first.
Partition was
That
happened.
I wanted to know, which
Please.
is that survey number 12.
It is earlier it was 12 bar 1A5, total extent. After the partition, POD was conducted. My extent was again coded as 12 bar 1A7.
1A7.
1A7, 1A5, 1A6, 1A7. 1A5 fallen to my elder brother, 1A6 fallen to in one more elder brother, 1A7 fall to my share. The government document I have produced.
Yes.
Sorry, madam. But again in the encumbrance certificate reflected as survey number 12 bar 1A5 of Abbigere. Though in the plain schedule, it is shown as agriculture land, but conversion order dated.
Court has come to the conclusion that without a trial, all these things cannot be decided and not granted injunction.
Please, madam.
Now, where are the other documents after
Please kindly see.
this order?
My limited prayer is only madam, not to change the nature and not to develop the land. This is only the minimum prayer I was before the court only.
Let's see the.
Please, kindly see the sale deed. It is in Kannada, the total extent 12 bar 1A5, page 36 for a moment.
Please come to that survey report.
Please. It is at
encroachment by the
page,
government.
page 51.
Page 50.
51, the translated copy I produced. Page 51, document number 9. It is in Kannada.
No, you said you have filed some translated documents. Where
I filed it. Memo along with that one, it is dated 29/8. In that.
First, some record of rights, Pahani.
Please.
Please straight away come to that survey report.
Please. Document number 9, not kindly translated copy I produced. Document number 9, page number.
As per the application number, measures are done and plan has been created. Has been identified.
Document number 9,
I'm looking at it. Translated.
In serial number 4, the survey number identified by the color 1.14 guntas. So number 13 has been encroached by Idvalidars.
What is that? Hinduvalidar.
Idvalidars, not those who are in possession. They encroached my property. Survey number 13 is in possession of the government. Government only encroached my property to an extent of 1.14 guntas. It is clarified even in this.
Let me understand this.
Please.
Survey number identified this by this color measuring so and so has been encroached by.
Survey number 13.
No. This Hinduvalidar.
Idvalidarus.
Means?
Those who are in possession.
Cultivators. From cultivators they have taken.
They are, no. They are, survey number 13, they are the Idvalidars. No, they are in possession. 13, it belongs to government. They encroach that particular marked portion of my property. This is my property. The box they have shown, it is kindly come to page 51 for a moment, Milan.
That I understand.
Please.
As per your translation, somebody who is like cultivating or who is in possession of the land has encroached.
Please.
Where from the government has come into picture there? That I want to know.
13, survey number 13 is in possession, government only, Milan.
But why did they say this Hinduvalidar?
In Karnataka, Milan. Suppose if it is, that is, survey number 13 is a cultivable land, it is an agricultural land. Above that, my property. My property is a converted land. Those who are in possession of survey number 13, I have encroached my property. This is the meaning.
So when they are conducting it, that's in the position of the government, that can as well be said.
They have encroached my, that is the case before the trial court. My case is, Milad.
What do you say?
I have no file, my lord. It may be.
What is no file? Last time also it has come up. Every time the same reply from you.
Misplaced and today I asked them to provide us file.
You have not given him a copy till now?
They only conducted a copy, everything
Not
is served.
survey report. He says he has no papers.
No, even I saw the copy. It is already admitted and the interim order was granted. Copy I have served
Who
already.
is your, who appears? The government pleader?
Earlier, Guru Swami was appearing earlier.
No, there will be hierarchy like above him over there.
For this matter, you are only appearing.
Last occasion he appeared.
And submission minute, kindly have it Friday minute. I will secure the section documents, have it Friday.
Let whoever is a concern, let appear. Why this matter we want, it should be simple issue. Post this matter day after tomorrow. By the time, whoever is the, that's what I'm.
AAG, madam.
Huh?
Additional AAG.
Additional AAG shall be present before the court and submit.
But that interim order,
Interim order earlier granted is
Please.
extended till then.
please.
How can the government do all this? You have to
Subsequently,
protect the interest of the common man, and you encroach his property and very comfortably your survey department, which is part of the government, gives a report saying that it is encroached. And still you people are not moving your little finger.
dishonorable court
Please
also.
get specific instructions. Will impose costs if it is right. And then we will, all the litigation expenses you have to pay.
By direction of this honorable court specifically, my lord, in the month of April, survey was again conducted. They also submitted report. Yes, government has encroached the property, my
Let
property.
him come, let's take additional AG come.
Please.
Cell number 34 to 36 adjourned. Cell number 37, Padira Rami Reddy. For appellant.
For appellant, your lordship.
Yes.
For the appellant.
Yes.
Suit for partition law, decree. And ex parte, more or
When
less.
was the decree?
The date not is 2016.
Hmm.
I have filed not miscellaneous petition, odd
When?
nine, in 2016, itself, within time,
Immediately.
within time.
Hmm.
And if your lordships are on dates, that synopsis may request not to take synopsis.
Partition on 1990.
But serial number 1, suit filed in 2011.
Hmm.
Serial number 2, my lord, decreed in favor of the respondents 3.
35, 2015.
Yes, ma'am. And I have filed, my lord, miscellaneous petition on 22/1,
Months.
after 8 months. I'm sorry, my lord, I stand corrected.
Hmm.
22/1/2016. Lord,
Let's go to the
after-
order. Let's go to the order.
Yes, ma'am. 3/7/22.
Who are you? You are the family member?
I am the family member. But it is not in dispute. Against me, my lord, partition is sought. My lord,
How many are the, let's look at the cost, come to the order.
Lord,
That,
your
where
lordship
is
would
the
kindly,
order?
kindly come to my lord, the decree, my lord, your lordship are looking at.
No.
Or
I'm
the
looking at
miscellaneous
petition.
order, my lord, is
Yes.
starts with page 14.
No, the miscellaneous petition is filed by how many? 5.
Five petitioners.
Respond, no, what is the relationship? Who are the plaintiff is, who are the plaintiffs?
Lord is the sister of the co-sister, sister of the, Lord, from the other branch. Sister of the appellants number 1 to 5. Cousin
Like,
sister.
One is Pagyamma.
Yes, ma'am.
Channakeshava is her brother.
Yes, ma'am.
Ratnamma is
Lord,
Pagyamma's sister.
May I request, my lord, your lordship could see, your lordship is at page 14, my lord.
Yes.
Lord, the first petitioner,
Hmm.
wife of Chikkapillappa alias Bodappa.
Hmm.
Then Lord, second petitioner, wife of Chikkapillappa alias Bodappa. Third petitioner, son of Chikkapillappa. Lord, this is the branch of
This is
Chikka.
one family.
Yes, Lord, Chikkapillappa alias Bodappa.
Second,
By Lord,
no, it says respondent number 2 is
Yes.
son
Yes.
of late Chikkapillappa.
yes, Lord, Lord, they were also not defendants before the, but miscellaneous petition is filed only by these petitioners.
Please come to know let's see the decree,
Yes.
page number.
Lord, page 47 is the miscellaneous petition itself,
47.
is the petition itself. And the decree, your lordship, judgment would start at page 35. Ratnamma, Lord, is the daughter of Pillappa alias Dodda Pillappa.
Minute one. $35.
Page 35.
Hmm. Hmm.
The lordship,
Ratnamma is the plaintiff.
Ratnamma is the daughter of Pillappa alias Dodda Pillappa. Lord, these persons are the brothers, that is Pillappa, Chikkapillappa alias Bodappa. And
Which defendant?
Lord, I am, Lord, for all the defendants number 1 to 7. Out of them, Lord, defendant number 1 to
7 are the appellants now?
Yes, Lord, no, Lord, 1 to 5 have filed this.
1 to 5 are the
Yes,
appellants?
yes.
Hmm. Hmm. Yes, now please come to the miscellaneous order.
Yes, ma'am. Miscellaneous order, may I request, ma'am? Page 14 onwards.
Lord, all that I am seeking, your lordship also take the order sheet, Lord, I have filed it along with the writ petition, but since it was some office objection raised, I had to withdraw the order sheet. Order sheet kodi. Huh? Order sheet then. May I just pass on? Lord, all that I am seeking is not an opportunity to contest this suit. Lord, how and why, Lord, I'll just order sheet, Lord, starting at page 20, internal page 2 of the order sheet.
Hmm.
Your lordship could see on the second half of the page,
Hmm.
on the left-hand side, where the registry would make a note. SS to D1, 3 and 6 duly served.
Hmm.
That is, my lord, appellant number 1, 3 and 6. 6, that is the respond number 2.
Hmm.
SS to D2, D4, D5 and 7. Served on D1, that is mother.
Hmm.
So, my lord, my respectful submission, there is no proper service on D2 and D4 because it was served on the mother, and the mother is an illiterate, not she has filed.
No,
But
anyone,
we have,
piece of paper, what she has, she will show it to the children.
it is there, not, but I have taken that contention. I just
That's
have
one.
to place it
Next.
to my lord's,
Next.
bring it to my lord's attention. And now coming to the merits of the miscellaneous petition itself, Lord, it's not, I have entered appearance through the advocate. Not the appellant number 1 and 3 are illiterates. They are not, and the other appellants are all not up to 4th standard they have studied. Lord, the main contention insofar as the partition suit is concerned, Lord, there is already an existing oral partition which has been acted upon. But that is the contention. After filing wakalat in the suit, Lords, there was a possible settlement, there was a discussion regarding possible settlement between the Ratnamma and the appellants.
Just coming up for admission.
Yes, Lord, today first time.
Hmm.
But after I filed wakalat through the advocate, there was a possible discussion regarding settlement. But in a bona fide belief, that is the evidence also on record. In a bona fide belief, we have not proceeded further with the instructions to the advocate to file a written statement, all those details we have not done.
What is the relief you are seeking now?
Not to restore, permit me to not contest the suit. All.
No, not
Yes.
the interim relief.
Interim relief regarding the FDP proceedings of. Your lordship may kindly come to page 11 of the petition. Interim relief.
Please come. Then counsel for the petition appellant submits that all the defendants were not properly served. They're illiterate persons. As such, they could not file the application immediately. It is submitted that there is an oral partition and it has been acted upon. When they file an application, the trial court had dismissed the same. Without considering the contentions raised on behalf of the appellant. They submitted that as this being a suit for partition. If the said order is not set aside, cause irreparable hardship to the plaintiff, to the defendants. Considering all this, they shall be stay of all further proceedings pursuant to the judgment and decree dated 3/7. What is the purpose of saying?
May not be, I may have to change it to the judgment and decree, not the miscellaneous order. Judgment and decree.
That's what.
Yes, I'll see. I'll just.
There
with my
shall be a
lord's
stay of all further proceedings pursuant to the
Judgment and
and decree dated.
It is dated 4/6/2015.
4/6/2015 till the next date of hearing. Petition is permitted, appellant is permitted to take out notice on the counsel appearing with respondent before the trial court and file a memo to that effect by 14th of October. List this matter on 16th.
Great.
Correct.
May seek my lord's leave to. carry
Correct,
it.
give him
Great.
to correct, for correction. Yes.
Great.
Yes, RPF.
Petition minutes.
Yes.
That's
petition of
agreed by the
government-
order, my lords, at page number 13 and 14, my lords, of the petition. My lords, the criminal miscellaneous dismissed for non-prosecution, my lords. Here, this RPFC, my lords, I'm praying to restore the miscellaneous, my lords, wherein the criminal miscellaneous is filed for the enhancement of the maintenance, my lords.
Please come to the order. Where is it?
Please, my lords, page number 13, my lords. 13 and 14, my lords. 13, my lords.
What is this criminal miscellaneous is of the year 2017?
Please, my lords. For enhancement of the maintenance, my lords.
This order is passed on 7/7/2023.
23, my lords.
When did you file this appeal?
This appeal, my lords, 22 February 2024.
Why?
My lords, as my paragraph, last paragraph is relevant, my lords. As she is studying in UP, my lords, we were not able to take the
You have
wakalat and
a, you have
affidavit.
an advocate, not that you have to come personally, physically. This itself shows that there are no bona fides on your part.
No, my lords, as she was studying in Uttar Pradesh, my lords, that's
You don't
the-
have an advocate. Is she pursuing it online?
Although she has given GPA to her mother also.
No, advocate is
Assets
there.
and-
Advocate is there. No,
Please.
because you're studying somewhere, as per your convenience, you cannot file the petition, sir. No, the court right from 2022 is waiting for you till 2023. And now now for filing this appeal,
My lords,
how many months? 5 months.
please, my lords.
Not 5 months. It's like 5 plus 2 months, 7 months. After 7 months, you file this appeal.
My lords, as that is the only main ground, my lords, that she was studying there, my lords.
For how long you will take the ground? Now, even if this is ordered, the same ground remains to be
Now
there.
she has completed, my lords, she is back to Karnataka, my lords. in
When
terms of
was she back to Karnataka? Tell the.
January 2024, my
Huh?
lords. January 2024.
Then what she was doing till February?
Lords, in the last week she came, my lords, subsequently, as soon as she came, my lords, we filed.
You don't want to
petition.
pursue a petition, why should you file it in 2017?
By then, my lord, she was studying in Shivamogga, my lords, here only in
Then
Karnataka.
why did you file? When you're studying in Shivamogga, why did you file the petition?
My
And you
lords,
can't pursue it.
by then she was pursuing, my lords, by then, my lord, she was
Not
studying.
pursuing education. When you can't pursue the litigation, why are you initiating the litigation?
My lords, 2017, she was studying in Karnataka, my lords, UG veterinary, my lord. Subsequently, she finished her UG degree and then she went to.
Please don't tell the court, people residing in US also pursuing the litigation. That's
Please,
not a ground. You don't have to be physically present. You can have one phone call to your advocate, will serve the purpose.
My lords, affidavit was.
There are no
filed-
bona fides on the part of the petitioner.
My lords,
Court was perfectly right. This
affidavit
court
was
finds no
also
reasons.
filed, my lords. Affidavit was also filed, my lords, that assets and liability, we were asked to file the assets and liabilities, my lords. We stated in the affidavit that there is no assets and liabilities for the petitioner as she is a student. She is not, she does
So
not
then
have
she
any.
should- there is a format. If there is a format, you can always, say that is not applicable, this is not applicable, but you can't say that I will not file.
No, my lords, we had filed, my lords, affidavit stating that she does not have any assets and liabilities, my lords. It was not considered, my lords. Prior to that, my lords, when the.
You should file it in the form. Saying that if whatever is the form, you should file it.
My lords, for that only we sought time, my lords. Subsequently, it got dismissed for now.
No, you are from 2017 without any interim order, you are able to leave.
My lords, there was an order, my lords, where educational expenses were supposed to be, supposed to be preferred by both husband and father and mother, my lords. From the year 2016, my lords, father had stopped paying the maintenance, my lords.
So 17 you initiated. You have no order in your favor from 17.
No, my lords.
Even till 2023 also, you'll be just file a petition and see what will happen till 2023.
No, my lords.
And again, 2023 petition will be dismissed. Now you are educated, now what do you want? You have
My
completed your
lords,
education.
mother had spent all the money, my lords. There is also a brother for this petitioner, my lords, whose education expense, all expenses was.
This court finds no reasons to interfere in
My
this.
lords,
Court is matter in the month of December 10th. And the request of land comes to the appellant.
please.
Yes.
My lord. Number 40 minutes. The serial number 40 minutes. The other side is also there. Last I refer them, maybe refer to
Mediation.
mediation center. Bangalore minutes.
Both the councils. submits, there's a scope for there's a scope for settlement.
What?
The council submits that there is a scope for settlement. The matter may be referred to the Bangalore Mediation Center. Both the parties shall appear before the Bangalore Mediation Center when?
Maybe next year, maybe. Before holidays starts, any day before holiday starts.
On 30th? On 30th September at 3 o'clock, Registrar Judiciary is directed to communicate the same.
My lord, interim order may kind.
Serial number.
Interim order, no adjournments now.
No adjournment, my lord.
Interim order earlier granted is extended till then.
There is an interim order in 24.1, my lord. That has
There is
been
an interim
extended.
order in that extent till the next.
My lords, the date was given.
Serial number 39, it is for dismissal of the petition. He has filed, he has taken not less than 4 years to, he is not coming at all.
That's why we'll dismiss it.
Sir.
We'll dismiss it after lunch.
My lords, serial number 27th, 30th was the date given.
Please don't tell the court all that. Everything, now it's already going to be signed. How many times the court will hear when the matter is called again?
No, my lords, we were present, my lords. Interim order has to be extended in 20.
That will be extended. No change of date will be given now.
My lords, will.
No.
Your lordship, serial number 19, your lordship, list to serial number 19. The only objection is that IA pagination is not done and index is not done. May I request for course of the day, your lordship, I'll comply.
No, it
List-
is not even called till now. Please wait.
Yes, your lordship.
Your Lordship kindly. Serial number 15, list number 1. The main matter is disposed of. I have challenged the trial court.
List number 2.
List number 1, my lord. Serial number 15 pass over. I have gone through the records. It has become infectious, my lord, because main matter itself was disposed of. I have challenged RPFC. In the RPFC, I have got interim order. Therefore, its petition become infectious. my lord.
The criminal miscellaneous petition itself is disposed of long back. And this will become infectious, dismissed as infectious. Yes, ma'am.
Number 230 matters. Say for order, serial number 1. Raghunath MD.
Give the file. That is the memo. There is this, better nothing. No representation for the appellant, post for dismissal. Yes.
Serial number 2.
Dismissal
of time to disposal of the matter.
This court by order dated 6/12/2023. I disposed of MFA number 4952 of 2008, directing the trial court to dispose of the MC within a period of 3 months from the date of the receipt of the said order. Now, a letter is addressed by the learned judge seeking an 8 weeks time accordingly, as per it was, the time is granted. Please, next.
Serial number 3. Ajay Shankar Rao.
Appellant.
Yes.
Respondent number 2 and 3. They are the daughters of the first respondent. Lord, he is served, represented through a council. All the rest of the respondents are all served. They all reside in the same address.
No. Now the notice has to go to R2
2 and
and
3.
R3.
Please,
You say that R1, R2, 3 are daughters of R1.
please. The other children are also served.
Who is represented by whom?
Lord,
Mr.
respondent number 1.
Nataraj?
Yes, my lord. He is representing respondent number 1.
Where is he?
Nataraju. Bhi hale mane.
No, whether he's, his instructions to accept notice for on behalf of them or not, we have to see. No representation for the respondent. Post is party tomorrow.
Great,
Counsel for the appellant is present. Yes, next.
great.
Serial number 4. Serial number 4. Sangamesh RP.
An office objection is raised regarding valuation. Lordships, my lords, give me liberty to file
What are you supposed to
miscellaneous
file?
appeal, my lords, before the. I am required to file the miscellaneous appeal before the district judge, my lords. The lordships, may I also request, my lords, to.
What is the impugned order?
Lords,
Order
the,
and rule 13.
lords, the order is under order 39 rule 192.
Hmm. Passed by whom?
Application filed by the trial court,
Additional civil judge.
additional civil judge, my lords, JMFC, Magdi.
Yes. The office has raised the on maintainability is order dated 29/2/2024, which is passed by the additional civil judge and JMSC at marketing. The appeal lies to the district court.
District.
District court.
Reserving
Instead of that, the appeal is filed before this court. The MFA is disposed of with the liberty to file an appropriate petition before
Yes.
the appropriate court. The history shall return all the records to the appellant. Yes,
With-
next.
Serial number
Lords,
5.
along with condonation of delay, my lords, the exemption of the pendency
No,
here.
that will, no, once the liberty is granted, that is covered till you approach this court.
Very well.
Before that, anything is there, you have to. Yes.
Serial number 5. Bhargav G.
Yes.
On complaint.
One of the plaintiffs has not been made as party because no relief is sought against her.
No, but the cause title should be complete as it was in the impugned order.
Since no relief is sought against.
So if you do not seek a relief, you have to write then.
That has been mentioned. We have mentioned as a note.
No, but first of all, cause title should be there as it is. Then below that, you have to mention that as no, we are not seeking any relief against that. They are not proper and necessary parties. Something should be there.
And we made a note, but if your lordships suggest, I will make necessary changes.
No note, but cause title should be there, then the note should be there.
I'll make
The
changes, sir.
objection shall be complied with how much time?
By Monday, we will comply. Matter may be listed on Monday.
The office objection shall be complied by Monday. If it is complied with, post the matter on Tuesday.
Yes.
Serial number 6.
My lord, I appear for the appellant.
Hmm.
My lord, the office objection is, my lord, that the schedule does not tally with the petition mentioned. Your lordship, I kindly say I have produced the petition page 33.
33.
3.
And where
Right.
is the present?
The present, this thing, my lord, it is at page, my lord, page 16, my lord.
Page number 16.
Yes. But these two properties are subject matter of will. My lord, the petition was filed, my lord, the petition is rejected solely on the ground. The will doesn't mention the executor of the will, and section 222, my lord, that is the only issue.
No. Simple is, it
Yes.
is not, both of them are not tallying. Where it is not tallying?
My lord, the office says, my lord, page 35, my lord. 33 and 35, they don't tally. That is the reason why, my lord, office annexure A is, my lord, for the purpose of valuation, my lord. Page 35, my lord. This is the valuation in that given, my lord, the schedule is given in that also, my lord. What is given the schedule in the petition is, my lord, page 33, my lord.
No, that I have seen.
Yes, madam.
It is not matching with, it's not with the page number 16. That's what they are saying.
That is what they are saying.
So where is it? What is that? It is not, what have you stated?
No,
other
no,
than-
they say, my lord, it is 31 P5. In two places, my lord, there is a, kindly see, my lord, page 35, my lord.
31 and
33 and 35, they don't valley.
dry land measuring
Yes.
14 guntas.
Yes.
Then where is this plus 0.02 guntas? Where from?
The
this has come?
second item. The dry land 0. So and so, at sale, page 31.5,
No.
situated
No,
at
no.
so and so.
Schedule property number 1. Dry land measuring 14 guntas with 2 guntas curb assessed at
Yes, madam.
2.29 of the bearing survey number.
Yes,
If
madam.
you come to the page number 35,
Yes, madam.
14 guntas, 0.02 guntas of curb,
That is item 1 is page 33, my lord.
0.29, bearing survey number 33 by P1.
It is your lordship get at item 1 in page 33, my lord.
So what they are saying is 35 and 16 is not.
Right. What I find, my lord, that there is a typographical error happened in the trial court itself insofar as item 2 is concerned, page 33, your lordship.
How the registry is concerned with what is happening in the lower
That's-
court there? Oh, basing on what is stated there, they have numbered it, the court had heard it, and an order is passed now. So now how do they expect them to correct these two, which is filed before the trial court? Where is the trial court? This is the. That they can know, how can.
My lord,
they
actually,
change
office, my lord, is virtually deciding the matter which this court should decide this matter.
So let us see, schedule it as normal, as before the trial court in your plate, what you have stated.
Yes.
That
my
is
lord.
matching with this. That is
Ye-
the same
Yes,
thing.
now what I have filed, it is matching, my lord, now.
Let's see, where is it?
That is at page, my lord.
33. So
16, my lord,
33
now.
No, 33 and 16 is one and the same.
33 and 16, one and the same.
Office objections with regard to the discrepancy is overruled. If it is, the other objections are complied with, list this matter for admission. Yes,
Tomorrow, my lord.
Serial number
Tomorrow, day, or next week,
next week.
please.
Yes, next.
Serial number 7. K.S. Mallikarjunaya
Yes.
Here for the petitioner, office has raised objections for second, first time I have compared all these. Second time they raise a page number 60, my lordship. It is not legible. It is a readable document. Why I have produced this to show that
No, the objections at, the present.
I
objections
made a
will be
submission. It is a readable. First time, whatever objections raised, I have completed. Again, when I move the memo, they raised an objection stating that
No affidavit. There is, what is it? There is not affidavit. There is no affidavit in
yes,
trial court.
125 trial court, they have filed application under 125. There is only application. There is no affidavit in the trial court. Whatever court has given, I had,
Petition J is legible and readable. That's
Yes.
your submission.
that is page number 60. Kindly see the page number 60, my lordship.
Page number.
60. Annexure J. I produced the statement account that you have taken avoid loan from SBI, that is 7 lakhs. 5 lakhs, sorry.
Generally, you have to make some effort to read it. That's
Two,
not that they
two
wanted-
document, just to show that I avoid loan, that's all. 7 lakhs, it is readable, my lordship. First time they have not raised this, otherwise,
Court has to make some effort to read it. That's why they have asked it.
lordship,
We should have filed it.
lordship, one submission, my lordship. I am not relying on that also. I am not relying.
The office objection.
1 minute, lordship, kindly peruse, because they are order higher to pay 15,000 per month.
At this stage, the court will not hear. It has to come up for in a proper heading. Either it should come up for a preliminary hearing or an admission. While it comes for a order.
My
we will not
submission,
hear
my
it.
lordship, it is a readable, just 7 lakhs is the loan.
That is what I'm going to say. Please wait. The office objections.
Maybe ruled, overruled, my lordship.
You tell the order, I will sign it. That's what I'm saying.
Because I am not relying on that also, my lordship. I straight away put, I am not relying on Annexure J.
Sir, office objections are overruled.
And unnecessarily they raise office objection, my lordship. First time I have completed everything. And when I move the memo again, they raise it.
Pose this matter for preliminary hearing.
Bill number 8.
And it may be taken up, Madam Chair, because tomorrow is the case, my lordship. Tomorrow is the case. If we before the trial court.
Pose this matter tomorrow.
Yes, my lordship.
Bill number
You
8.
just can't keep quiet without complying with the objections, and you can't pressure the court that. it
And
should
I
be
had
taken.
completed it, my lordship. Last, when I moved the memo, they raised it.
This matter, right?
Bill number 8.
Petitioner,
Yes.
your lordship, on 13/9, we have complied the office objection, your lordship. And
Para
further
numbers to be stated correctly at a verifying
affidavit,
affidavit.
your lordship. And
Jurisdiction to be stated correctly at cost title. Annexure
Yes, sir.
has to be attested by competent authority.
annexure H, we have.
Annexure details to be stated correctly at verifying affidavit.
Please, I'll comply it right now, your lordship, if your lordship permits me.
Why don't
Is
you
a-
complain when it is there before the registry?
Your lordship, on 13th, they have raised office objections, your lordship.
Give
They
it
have
to
raised further of.
Give it to him, let him correct. If the office objections are properly carried out, pose
Yes,
this
sir.
matter for admission. Yes, next.
Your lordship, this is a matter of urgency, your lordship. The
The court can't help it. Please don't tell the.
Bill
court.
number
Let-
9.
by once it is
lordship,
there, it will come.
kindly have it on tomorrow, your lordship.
No.
I'll comply it right now, your lordship.
No. Yes, next.
Bill number 9. P. Vachan.
I appear for the petition in this matter, my lords. Lords, the only objections that was raised was that a copy may be served on the caveatar. The advocate who appeared for the caveatar, we served a copy on him. He told I've given NOC on the same day. Therefore, we did.
No, he's
For the
here.
respondent here, my lordship.
Now, a different advocate has come on
No,
record.
give him.
Please, a copy is ready.
Yes.
I'm serving a copy.
Pose this matter, or the learned counsel has served a copy on the counsel appearing for the respondent. Pose this matter for preliminary hearing.
My lords, if I may make one submission, my lords. My lords, the matter is listed before the trial court today, since we were unable to get the new lawyer on record till yesterday or day before yesterday. My lords, it's an interim prayer may kindly be considered.
It will not be, no, once this court starts this practice of hearing at the stage of orders, then it will be very difficult. Pose this matter
Kindly.
for admission on Monday, for preliminary hearing on Monday. Yes, next.
Grateful, my lord.
Non-compliance, second time, cell number 10. Rajesh.
I appear for the appellant, ma'am. 2 weeks time may be given.
No, 2 weeks, 1 week.
1.
A week's time, default order, 10.
Cell number
Much of-
11. Suresh MG,
No representation for dismissal.
serial number
Tomorrow for dismissal. 12.
Prakash Angadi,
Appear for appellant, raise times.
Weeks time, 12. Same default order,
serial number 13,
13, 14, 15.
Prashant BR,
Prashant BR. No representation for dismissal tomorrow. Next 15.
number 15,
Yeah, for the appellant in this case.
Sumang.
Lord, there are two office objections that they have raised. One is, my lord, the address of respondent number 6. My lord, I have made respondent number 6 as John Doe Ashok Kumar. It is a blanket injunction that I am seeking against all the media people. So question of me furnishing address of John Doe, my lord, may kindly be dispensed with.
With against anybody you're seeking an injunction, there
Yes,
should
my
be an
lord.
address to him.
No, my lord,
There
in the,
can't be an injunction against.
no, my lord, there's a provision to say John Doe or Ashok Kumar, especially when it comes to media houses publishing articles. I cannot, it is not possible for me to make all the media houses a party. I have made certain media houses a party who have actually published it. The rest of them, my lord, I have not made a party.
What is the
Even in the plaint, my lord, may kindly turn to page 55 of the petition.
50?
55 of the petition, that is the plaint filed before the trial court. Even there, my lord, I have just stated Ashok Kumar, John Doe.
Who is he?
My lord, that's a blanket covering all the media houses, my lord. That's permissible, my lord. It's not a particular person.
How can there be an order just like that?
My lords may kindly grant me time till Monday. I'll
Yes,
furnish some
Yes, we'll
material to
understand.
convince this
So that
honorable
you can
court.
enlighten the court. Pose this matter on Monday. Yes.
serial number 16,
My lord, there's one more office objection, my lord. When the certified copy in one of the pages, the signature of the presiding officer is not forthcoming.
Give that. Office has raised two objections. One is, where is that? Page number? Where is that?
CS7.
No, where is it? Take him and get him signed. That's what I am saying. How is it possible? All these kind of objections. What they will do if he's not signed? The main order itself is not signed. Mr. Counsel,
Yes, my lord.
the main order itself is not signed. How can, it be a copy?
It's a certified copy that I've issued, my lord. I'll apply for another one.
Please.
The
do.
least. Yes, my lord.
I was thinking in between somewhere the signature is missing. The office objection. The objection shall be complied with. Pose this matter after 2 weeks. Give a date.
My lord, for the first objection, my lords may kindly post it for hearing on that objection itself, my lord, because I will not be able to
That
comply.
is done. That's the main, the order itself is not signed by the officer.
That I will
Court
comply
can't
in 2
hear.
weeks' time, my lord.
2 weeks time when it comes after the then if you argue before the court, that day we'll say that.
All much obliged.
Yes.
14, serial
16.
number 16, Prakash Angadi, BV,
Appear for appellants, raise times.
Weeks time. Default order 17.
17,
Same order.
Prakash Angadi,
18.
18,
We appear for petitioner, my lord. A week time may be granted, my lord,
Same default order 19.
serial number 19, Santosh S. Gogi,
Weeks time. Then you should have done it by this time. If the office objections are complied with, post this matter day after tomorrow. Yes.
serial number 20, 4th time officer petition,
Appellants,
Prakash
raise
Angadi,
times.
Weeks time, same default order 21.
serial number 21,
For the petition in this case, madam, pray for a 2 days time, my lord.
Why?
21.
2020, not
21.
recalling application is also pending.
Please.
Give this, if I remember, some time is granted.
No, my lord, first time this coming for.
But then if recalling application is pending, how will you comply with the office objections unless?
That
the
is the
court
problem, my
has
lord,
to-
because I haven't find.
Petition, no, there is an order by this court also.
Not this court, my lord, the coordinate bench of the.
Petition is dismissed for non-prosecution on 12/6/2024.
Please, my lord.
IA number 1/2024 is filed for recalling the same. Pending consideration of IA number 1, petition is permitted to comply with the office objections within 1 week. This order is on 19/7/2024.
Please, my lord, because when I went to the office, my lord, the file was not there, my lord. That was the difficulty, my lord.
Why
So,
the file will not be there in the office?
when I went to the pending session, they are told,
Here today, so it must have been there in the section.
please, my lord, 2 days time. my lord.
So you sought for a week's time on 19/7. Where are we now? And already the recalling application is pending.
Please, my
So
lord.
why should we entertain this? Pose
Finally,
this matter day after tomorrow. By the time with the office objections are not complied with, without further reference to the court, the petition shall stand dismissed. Yes, next 22.
Number 22, Dhananjay Kumar.
to the petitioners, my lord, I kindly pray for 1 week.
Week's time, default order, yes, 23.
22.
Lordship, I representing the petitioner, Lordship. Week's accommodation may be provided, Lordship, to
Week's time, default order, next 24.
Grateful, Lordship.
If I appear for the petitioner, the first petitioner, my lord, she is a deserted wife. She has to come from Shumaga with a minor child. There is a delay in filing the petition, my lord, 300 days. I have prepared the affidavit and I will send me. May I request for 2 weeks' time, my lord.
A 2 weeks' time is granted, same default order. Yes.
List number 1. Sale number 39.
Responded to this.
April 20.
Yes.
He was due 1.44 lakhs.
You are for the respondent.
I am for the respondent wife and child. Regarding wife, it was stayed. Regarding child, 3,000 rupees per month was fixed to be paid. He himself undertook. There is an order on 7/2/19 by this honorable court.
On 21/12/2024, as there is no representation on behalf of both the sides, the matter was directed to be listed next week. When the matter came up before this court on 5/4/2024, again, the matter was directed to be listed for dismissal on 24/4/2024. Then on 24/4/2024, this court has passed an order, is directed to delete the matter under the caption dismissal. Pose the matter after summer vacation 2024. Again, it has come up before the court on 31/8/2024. Even as that day also, there is no representation on behalf of the petitioner. This court has observed that the RPFCs of the year 2016 and directed the matter to be posted for dismissal on 17/9/2024. Either in the forenoon and even in the afternoon also, there is no representation on behalf of the petitioner. It appears that he is not interested to pursue the matter. Accordingly, the petition is dismissed for non-prosecution.
Sale number 40, urgent. Sale number 41. VD Raviraj for petitioner. G. Swami.
Petitioner, man. The 125 proceedings was challenged.
Where
It
is
is
the respondent?
no one
No
repres-
representation on behalf of both the parties.
and the earlier date of hearing also nobody. was
None counsel for the respondent present, none for the petitioner.
I am for
No,
I-
earlier.
early.
None for, on 23/7 when it has come up, none for petitioner. None counsel for respondents present, leaves the matter on 19/8/24. And on 19/8/2024, no representation on behalf of both the parties. Pose this matter on 17/9. So,
Right.
one more opportunity needs to be given to him also. The counsel for the petitioner is present, no representation for the respondent. Finally pose this matter on
It was,
21st of October.
So for children is concerned, we have not challenged. Both the children are with me now. Only the medical expenses given to the PW1, my lord. Even petitioner was dead. It was ordered to go to the PW1 because it is court traveled beyond the pleadings. That is what our.
These two serial number 8, your lordship, I complied the office objection. Your lordship may kindly have it tomorrow.
They have to see whether it is complied or not.
So
If
they-
it is complied, if the office objections are complied, pose this matter day after, not.
Your lordship, the child is suffering from eye problem, your lordship. The trial court has ordered for video calling every alternate days. Yeah, it is causing lot of
Hey,
problem.
what will happen? Tomorrow, day after tomorrow, it's been happening from a couple of days, isn't it?
Your lordship,
You can tell the father that he is suffering with eye problem, won't he understand that?
no, your lordship.
We'll
He's-
see day
he's
after
calling
tomorrow.
every day, your lordship.
Pose this matter day after.
Much okay.
2110.
ಹೇಳ್ಬಿಟ್ಟು comply ಮಾಡ್ಬೇಕು. ನೀವ್ ಮಾಡಿದ್ರಾ? ಹೇಳ್ಬೇಡಕ್ಕೆ? Comply with submission of the court ಅಂತ ಬರೀರಿ. ಇವತ್ತಿನ date ಹಾಕಿ. With permission of the court ಅಂತ ಬರೀರಿ. ಇವತ್ತೊಂದು ಡೇಟ್ ಹಾಕಿ ಅಲ್ಲಿ. ಮೇಡಮ್ ಈಗ ಕಳಿಸ್ಬೇಕಂತ. ಡೇಟ್ ಅಂತ ಕಳಿಸ್ಬಿಡಿ. ಮೇಡಮ್ ಇದು ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಕಳಿಸ್ತಿಲ್ಲ ನಿಮಗೆ. ಕಳಿಸ್ಬಿಡಿ. ಇದು ಡೇಟ್ ಇತ್ತು ಸೈನ್ ಮಾಡಿ ಕಳಿಸ್ಬಿಡಿ ವಾಪಸ್. ಪುಟಪ್ ಆಗ್ಬೇಕು ಅದು ಬ್ರಾಂಚ್ ಆಯ್ತಾ. ಬೇರೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಕಂಪ್ಲೈನ್ಸು ಅದೆಲ್ಲ ವಿತಿನ್ 2 days ಅವೆಲ್ಲಾನು ಕೊಟ್ಟೆ ಬಿಡಿ. ಸೈನ್ ಮಾಡಿಸಿ. ಇವ್ರು ಹೋಗಲ್ಲ ಅಲ್ಲಿ ಹೋಯ್ತಾರೆ ಫೈಲ್ ಇಲ್ಲ ಬಂದಿಲ್ಲ ಅಂತಾರೆ. ಆ ಥರ ಎಲ್ಲ ಆಗ್ತಾರೆ. ಟೈಮ್ ಆಗ್ತದೆ. ಅವ್ರ ಪ್ರಕಾರ ಏನ್ ಗೊತ್ತಾ ಮೇಡಮ್ ನಿಮಗೆ ಹೇಳ್ತಿದ್ದಂಗೆ ತಪ್ಪು ಬರುತ್ತೆ. ಅಲ್ಲ ಅವ್ರದ್ದು warning list it will be added to the regular list. You have to wait. Warning list will not be called out today. It will be added to regular list. That is, you have to be getting ready. That is for warning. You should not seek attendance in that when it is listed regular. Today no. No.